May I Lordship? I beg to mention item number 2 on behalf of our Sonar.
Item number 2.
Yes, Lordship. And we have taken consent from order 30. Leading counsel is unable out of session.
Who is for the respondent?
Yes, my Lord, I am
The matter is ready for hearing, I think. Mr.
BCO.
Land Council appearing on behalf of Mr. Rajesh Sonar, Land Council for the appellant. Staff also heard Mr. M. Roger, Land Council for the respondent. Sole respondent. Okay, stop. The pleadings are complete and the matters are ready for hearing. Stop. Accordingly, list this matter up for hearing. After or in usual course?
3 weeks.
After 3 weeks.
Yes.
Okay.
May, my lord?
Yeah.
My lord, I would like to mention item number 19, my lord. Matter is fixed for hearing. My lord, I'm for respondent. I have already taken consent for opposite party.
Item 19.
Yes, Your Honor. Your
What do you want? Adjournment.
Exorman, Your Honor.
You are on behalf of
A respondent.
respondent.
Yes, Your Honor.
You have informed the appellant.
Yes, sir.
You are Miss
T said,
T.
SETH. T said.
Your name is there.
Your Honor, in causes there is not reflected, but
You are appearing on behalf of
respondent.
respondent.
Yes.
Your name is there in the Wakalatnama.
Yes.
Have you filed?
Yes.
Name is there in the then cause list.
Here is not reflected, but
Okay, Miss
T said.
Land Council for the respondent with the consent of the Land Council for the petitioner. Praise for adjournment of the matter for 3 weeks.
3 weeks.
The prayer is allowed. List this matter after 3 weeks. Okay.
Item number 1.
Okay. Heard Mr. A.K. Singh, Land Council for the petitioner. Also heard Ms. L. Hage, Land Additional PP. Staff. This application has been filed. So this application is under section 483 of the Bharatiya Nagarjuna Surakshita Sanhita 2023. Has been filed by the petitioner. Who is the petitioner? Is the accused? Petitioner?
No, cousin brother.
Okay, petitioner for seeking release of the accused who has been arrested in connection with the ITA WPS number 03/2025 under section 137 within bracket 2 stroke 87 of the BNF trade with section 6 of the protection of children from sexual offenses. Call for the scanned copy of the still under investigation.
No, Lordship, charge sheet.
What is the status of the case then? Stage, what is stage?
Charge frame. Your
Charge already framed. Have you appear whether you filed bail application before the trial court?
Yes, that has been rejected.
It was rejected. When it was rejected last?
Was rejected on 37/25.
There was after framing charge only? After framing of charge
Lordship.
only your bail was rejected.
Lordship.
On merit.
He is under custody, Lordship, since 26 to 20, since February.
Since February
Lordship.
2025.
Lordship. 26 to 20.
Now, but now charge framed.
Yes, Lordship, charge has been
And
framed.
after
And
framing of charge, you made you moved the bail application before the trial court. It has been rejected. Merit. considering that there is a prima facie case against him.
I do agree, Lordship, but the dates are being fixed. He is under trial. Dates are being fixed long, very long. Now the matter is fixed in the month of October.
Okay, so any circumstantial changes thereafter, after rejection of the bail by the trial court?
No.
No changes.
Circumstances,
Now, on the same ground, do you expect that the bail will be
no,
granted?
my contention, otherwise your Lordship can direct the trial court to expedite the matter. Lord. Because he is custody.
Okay. How
And,
many witnesses is
he has
there?
been produced
How many
after
witnesses?
14
How many witnesses? Prosecution witnesses are there in the case?
Not much witnesses.
Any witnesses have been examined by now?
No.
Not yet.
No.
It will be difficult then in that
Because
case. You want this court to direct the trial court to expedite the trial?
and because he is under trial, your Lordship.
Then can we dispose of
He's
with
already
with
under-
that direction?
Yes.
Hmm?
Yes.
Or record need to be
And-
called?
Or date can be fixed after fortnight, 14 days, as and when he was produced before the trial.
Call for a stand at least this matter after 2 weeks. Okay.
Lordship, can it be fixed on 27?
Just a minute. This is POCSO Act. Then notice is to be also to be
Yes,
issued.
I have made party also.
It will be okay. Then call for the scanned copy of the trial court record. Issue notice. The petitioner shall Ms. L. Hage, Lanet additional PP, accept notice on behalf of the state respondent. Number one, no formal notice need be issued to the state respondent. The petitioner shall take steps upon the private respondent number two by a registered post with AD, as well as by usual process within a week from today. Please this matter after 3 weeks.
Yes, can be fixed on 27?
No, because see, take a step first. Take a step.
Yes, sir.
Okay. Okay. Now,
The rest,
then notice upon the respondent of the petitioner shall take steps upon the private respondent through office of the PP
that has to be routed through registry.
to be routed through okay, to be routed through registry. Okay. Okay.
Item number 3,
Within a week. Within a week. Huh?
No, this morning I filed an additional, I called for the affidavit.
Of course.
That what I spoke to madam.
Okay. Hmm. In this regard, yesterday I have already passed order that has not been incorporated in yesterday's order because this is to be passed today only.
Yes.
So,
So this the order is last case 111.
so the only the order, the GR number was to be mentioned.
Yes, session case.
So since you have mentioned,
Session case.
yesterday I have already dictated. So rest only this order was not there. Order or the GR number was not there.
Session.
Sessions case, sorry. Sessions case number was not there. Mhm. You are for? SIT. Okay. Yes, we knew that. So now the rest will be. Was like that. Keep that point.
Stay part this number is required.
Hmm?
Yesterday for stay part this only there section case number. No.
Yes, that part.
Yes, madam.
It was already recorded by the and then in the last, I had Mr.
Scheme.
After his party name also would be same as committee, land council for the petitioner. And the respondent also for SIT.
Let's page 22, my lord, 23, my lord. 22, my lord, 22 start, my lord, please, last, in the prayer.
Just a minute. This application under section 528 of Bharatiya Nagarik Suraksha Sanhita 2023 filed by the petitioners with the following prayer. I, your first prayer is to set aside.
Search sheet, my lord, and the thereafter, my lord,
Set
cognizance order, my lord.
No, what is this 5/6/2024?
5/6, this is cognizance order, my lord.
Okay, where is charge sheet date?
Search sheet, my lord, is 4/2/2000, my lord. This is in the page 23, my lord.
And what else?
What else, my lord? The committed, my lord, by the learned minister, my lord, and 30,
Committed on date, which date?
306 to 2020, same page 23.
Okay. 4/12/23. The one, the charge sheet number, the number 54/2023 dated 4/12/2023 filed against the petitioner for offense.
Under section, my lord, 304,
Under
326,
section 30,
304, 326,
304, 36,
323,
323,
and 34 IPC.
and 34 IPC.
Is page 46, my lord, annexure C, my lord.
Okay. Number 2, semicolon. Number 2, the the order dated 5/6/2024 5/6 is
My lord, page 64, my lord.
page
64, my lord.
5/6/2024 passed by
Judicial Minister first
the
class.
Learned Court of Judicial Magistrate First Class Capital Complex, UPIA, Capital Complex, UPIA, whereby the Learned Magistrate has taken cognizance of the offense semicolon and
Page 92, my lord.
is and is
92, 92. 306 to 25.
and order dated 30/06/2025. This order was passed by
Passed by same
Passed by.
Judicial Minister first class UPM, my lord. Same court,
the Judicial Magistrate First Class, UPIA.
Capital Complex. Considering submission committed. My lord, it is considering the submission made by the faction of the 304. It is exclusively tribal court of session is committed.
Okay. By which the case has been committed to the Court of Sessions. Committed to the Learned Court of Sessions, Papumpare District, UPIA. And
That much, my lord. That 3, my lord. My lord, the order, this additional affidavit, my lord, this order of this court,
Okay.
session two.
Para. The petitioner contended that the provision under section 6 of the armed forces within bracket special powers bracket close 958 is mandatory and non-compliance therewith would vitiate the prosecution or legal proceedings. So he further submits that the petitioner further contains that subsection 2 of section 197 CRPC also protect.
My lord, now it is my lord,
Protect.
now you have my lord 218 to.
Okay. 2 of section 197 CRPC with corresponding to
218 to
218 within bracket 2
BNS.
of BNSS bracket close also protect the armed forces from prosecution without obtaining prosecution sanction. So it is submitted that the police could not have submitted charge sheet, and the learned judicial magistrate first class could not have taken cognizance of the case and committed the same to the learned sessions court without prosecution sanction.
Session के committee to my.
That is why I'm saying.
Yeah.
However, in the instant case, the IO of the case has filed charge sheets against the accused. And the judicial magistrate first class has taken cognizance of the case and also committed the case to the court of sessions, session court for trial and disposal without any prosecution sanction obtained against the accused persons. Issue notice returnable by 4 weeks. The petition no, this is only on the state.
I will decide.
Since the special public prosecutor SIT has already has put appeared and accepted notice on behalf of the respondents. No formal notice need be issued. However, the petitioner shall furnish extra.
Hello, I already served my lord.
You have served.
Yes, Lord. I have received a copy.
Okay, served requisite extra copies if not furnished, not yet furnished. Okay, to the learned counsel for the SIT if not yet furnished. Stop. Para. In the meantime, list is matter after 4 weeks, huh? In the meantime, the proceeding, where have you mentioned the proceeding
My lord,
number?
yes, I've mentioned, it is, my lord.
Hmm?
Paragraph, my lord, 6 and 7. my lord. This one.
Where is the number? Number,
Number, case was registered as session case number 20.
page, para 7.
Paragraph 6 of the 7, both here. Six.
Say one, which one?
Paragraph
First,
6.
where?
Paragraph 6.
We don't record 2,
Paragraph 6.
6.
Yes, ma'am.
Where is number?
And 104 page, madam. The case of
Okay, the proceeding of the sessions case number 17/2025 arising out of, where is the PS case number you have mentioned? Arising out of
PS case number, my lord, Longing PS case number.
Longing. Longing PS case number. Where do we find?
My lord, it is my lord, 111 page, my lord, order itself.
Hmm?
111, my lord, it is like, when the order of the session total.
111. Okay, arising out of the, okay, Longding PS case number 27/2020 under section 304, 326, 323, 34 IPC shall remain stay till the next returnable date. What this is matter after 4 weeks.
May I pray date, my lord? I'm coming from Guwahati, my lord, so. Any date, my lord, your lordship, my lord, suggest. After 4 weeks, my lord.
Okay, then just a minute, huh? Then we have not called for the scan copy, huh? Call for, before issuance of the notice, call for the scan copy of the trial court record. Okay. Then at least is page grade 4, comma, least is matter on
15 lordship, 1/5.
1/5.
After
9.
9. 24th, my September, my
Hmm?
24th September.
24 September 2025. Okay.
Highly obliged.
Item number 4,
Right, please, your lordship.
Hmm.
CD was called for updated. Earlier, there was an allegation that he was not cooperating with the investigation. But your lordship, now he's cooperating with the investigation. And moreover, your lordship, the allegation, if we see the face of the FIR, your lordship, it's more of a civil dispute
nature,
matter.
civil
Yes,
nature.
your lordship. So
You can
in this
make-
kind of cases,
Make
not
it absolute.
yes, your lordship, with the same terms and conditions. That's
Yes, the same terms. and
Yes,
conditions.
your lord.
Okay. Miss D. Rilo, Land Council for the petitioner. Also had Mr. T. Land additional PP for the state respondent, staff. Para. By an order. Just a minute. Huh?
23/6.
Okay, just a minute. Huh? This is application under section 482 of the Bharatiya Nagaric Surakha Sanhita 2023 has been filed by the accused petitioner seeking granting of pre-arrest bail, apprehending his arrest in connection with the Papu Hill Police Station case number 60/2025 under section 420/406 of Indian Penal Code. Which was that there? Okay, stop. Huh? Para. By an order dated 23/6/2025, the accused applicant was granted interim anticipatory bail with the direction to cooperate with the investigating agency and to appear before the IO of the case. And not to leave the jurisdiction of the police station without permission of the IO of the case. Staff, in compliance of the said order, the accused applicant appeared before the IO of the case
My lord, on 8/7/25.
on 8/7/2025. So on his appearance,
He was arrested.
he was arrested and executed a bail bond of rupees
50,000.
50,000 and thereafter.
His statement was also recorded and
Ah,
released.
Okay. Okay, his statement was, his police statement was also recorded and thereafter. And after completion of the procedure, he was released on bail in terms of the interim anticipatory bail granted to him. Staff. The para. The Larry, sorry, it is submitted that. Sorry, just the record reveals that the accused is now cooperating and appearing before the eye of the case with the investigating agency, and he is appearing before the eye of the case as and when called for. And he's under the and since the accused applicant is cooperating and appearing before the eye of the case, this further hospital interrogation is no longer required. Okay. In view of the above, and considering that the accused applicant is has already appeared, he was he was arrested and released on bail on execution of bail bond in terms of the anticipatory bail granted to him on 23/6/2025. And also considering that he is cooperating for investigation of the case, this court is of the opinion that the custodial interrogation of the accused is no longer required. In view of the above, the interim anticipatory bail granted to the accused applicant on 23/6/2025 is thereby made absolute on same terms and
Yes, your lordship.
as stipulated in the.
Yes, yes. Only the last condition has to be, your lordship, strike out because it was a direction to appear within 15 days. So that part is already complied. The other condition will remain intact, ma'am.
Okay. Made absolute subject to the same terms and condition as stipulated earlier.
Yes.
Any further?
Further is not required because that order covered everything, my lord. To cooperate with the investigation shall not leave the jurisdiction of the
Yeah, that
concerned
is there.
without
That
the
is-
IO.
That
Yes,
is already there.
yes. Oh, everything is there.
Okay. Above this bail application stands disposed of.
Obliged.
Matter number 5. Hey, Lordship, matter may be possible of timing.
Password for time being.
Yes, Lordship. The council is engaged in the next bench.
We have not received the case diary in this case. And he is already under protection.
He is under protection. Case diary not yet received.
He has not received case diary, my lord. So since they are already in interim protection, your lordship, kindly grant us further time, your
Okay,
lordship, so that we
okay.
can
You are
produce the
Mr.?
case diary.
T comes, sir.
Learned counsel for the petitioner is present. Staff, Mr. T. Learned Edison PP, raised for further 1 week time. to
Yes, your lordship.
Produce the scanned copy of the case diary. They are allowed. This is matter after a week. Okay.
Yes, your lord. Oblige, your lord.
Item number 6.
Lordship, though we have received the CD, Your Lordship, the CD does not contain the statement of the witnesses as well of the accused, Your Lordship.
Okay.
CD contains only the case diary that they make during regular every day of the investigation, Your Lordship.
But the fact remains is submitted yesterday. The main accused against whom the FIR was lodged
Yes, Your Lordship.
has not been arrested.
Your Lordship,
And the
The-
co-accused has been arrested, has been released.
no, Your Lordship. In this FIR, Your Lordship, the
It
applicant
is
here is
against
the main.
MLA. It is against MLA who brought other person, and this other person, including the present accused persons.
No, Your Lordship, in this FIR, Your Lordship, the applicant is the main accused, Your Lordship. He's a teacher by profession and he has been selling the item 6. Lordship.
Okay, item 6 is different.
Yes.
Yes, yes.
So we'll
Yes,
be needing an
I thought the advocate who appeared in this case. Okay, this is, just let us see.
Lordship will find the FIR at page number 24.
Twenty-four.
Yes, Your Lord.
Okay, this is NDPS case.
NDPS case.
Right. And then earlier you made bail application, moved bail application before the trial court.
Yes, Your
It
Honor.
was rejected.
Yes, Your Honor.
And the Learned trial court has made an observation that there is a potential interference with evidence, tampering or witness,
No, Your Honor.
or intimidation also. Recently, it was rejected.
Bail rejection order of the trial court is annexed on
30.
page number 30, Your Honor. Your Honor, the grounds for the rejection was that, Your Honor, as part of statement of IO, Your Honor, more witness need to be examined. This was the ground, Your Honor.
The
But since
substances recovered from him is intermediate. quantity.
intermediate, Your Honor,
Intermediate.
8.71, Your Honor.
What is the comments and the stated bail comments?
Your Lordship, therefore, the IO of the case is on leave because sickness leave, Your Lordship. The
Yep.
OC of the case has forwarded the case diary which does not contain any of the statements of the accused as well as the other witnesses, Your Lordship. We'll be at least needing those statements.
In this- Objection. There is objection.
There is an objection.
60 days also not yet completed. Mandatory period also not completed.
Yes, the investigation is pending for examination of other witnesses as well as the report of the FSL, Your Lordship.
This is still under investigation. And then if intermediary, what is the punishment? There is a minimum punishment also.
Yes, Your Honor.
Intermediary.
Punishment,
Minimum is 10.
Your Lordship,
Minimum is,
minimum is 7.
21B, Your Honor, it's maybe extend up to 10 years. And 27 is for 6 months and 3 months, Your Honor. And Your Honor, as per the, Your Honor, FIR, Your Honor, on the first, Your Honor, first para, the IO have alleged that the LS accused is involving in peddling. But Your Honor, that alleged charges is of, Your Honor, is of possession and consuming. And moreover, Your Honor, in the last, Your Honor, in the last para of the FIR, the informant himself is the investigating officer, Your Honor, in this case.
There's no.
So, Your Honor, in the last para of the FIR is mentioned that the search and seizure were videographed. It's in the page number 25, Your Honor, last para. The search and the seizure were using the e-Successive app during on the spot interrogation. Billy Potong revealed that he had purchased the suspected heroin from one Doke Talu by in Basar, Your Honor. He was detained at the scene and brought before the police station. Your Honor, it's never mentioned that LS accused was selling, Your Honor. And moreover, Your Honor, the charges is of, Your Honor, consumption, Your Honor.
no.
The second paragraph of the FIR itself says was selling heroin from his OBT government quarter.
Then, Your Honor,
He has been selling contrabands from the government quarter and he is a teacher and he's selling in the school.
yes, Your Honor,
Very difficult.
this allegation only, Your Honor. And now, Your Honor, my humble prayer, I maybe give opportunity to face the fair and impartial trial before trial court, Your Honor. So, LS accused being a government employee, Your Honor.
You have any doubt?
The prolonged detention of the LS accused not only caused irreparable loss to his career and his, Your Honor, future, but there is an acute shortage of the teachers in school, Your Honor. So,
He has been alleged of destroying the career of his student.
Your Honor,
And you are talking.
Your Honor,
about
this
career
is
of
the instant
person who destroyed.
instant case only. He's been, Your Honor, alleged. Since he's serving as a assistant teacher since 2023. But there is no any, Your Honor, antecedent or records.
What is this then? This record is enough.
And Your Honor, moreover, Your Honor,
Recovery of this, so many items, see?
Your Honor, in this case, Your Honor, police investigation or arresting authority didn't comply with the mandatory guidelines and provision of the NDPS Act, Your Honor. The police at around, Your Honor, 8:50 p.m., Your Honor, around 8:55 p.m., two police personnel, Your Honor,
Red color, yellow color tobacco container, trace amount also. Black and gray color, black. My syringes, screw number. Mobile 4 number. It's very difficult. Those were being videographed.
and Your Honor, after searching of long hours, more than 6 hours, this suspected contraband has been seized, Your Honor. Your Honor, so it's very doubtful, Your Honor.
So what do we?
And moreover, it's more than
Lordship,
50
pass on the
days.
basis of the,
yes, Your
That was-
Lordship, if Your Lordship is,
so now at this stage, because this under active investigation, still under active investigation.
Yes.
I'm not inclined, bail rejected. Huh?
deeply.
Your Honor, at least I seek, Your Honor, adjournment,
You
Your
are
Honor, at least
Mr.
L. Gillen, Your Honor.
As Jillian, Rani counsel for a petitioner.
I seek adjournment, Your Honor.
Also had Miss.
At least it may
Gillian,
list after
additional PP. for
2 weeks,
state
Your Honor.
Respondent, staff para. This application filed under section 483 of the Bharatiya Nagrik Suraksha Sanhita. The petitioner seek release of the accused Billy Potom, who has been arrested in connection with ROPS case number 35/2025 under section 21B 27 of NDPS Act. The prosecution case is that the accused who is a teacher, an assistant teacher, within bracket IQ, was found selling heroin from his OBT government quarters at government secondary school Pakam, from Alo. On receipt of the information from the sources and on the direction of the superintendent of police, Alo, the police team raided the raided the quarter of the accused and on search after giving proper notice and observing all the legal formalities are contraband was recovered from the possession of the accused. Contraband substance in different colored of tobacco container containing suspected heroin were recovered from the possession of the accused, along with the cash amount. Cash amount, sky date, syringes, and mobiles, mobile phones, mobile phone handsets containing mobile phone. Okay. Mobile phone. Accordingly, a case was the aforementioned case was registered against the accused and arrested on the same day on when it was arrested
24/6/25.
24/6/24. 14/6.
It's written, accused
14 or 24?
24.
240.
24/6.
Yes, sir.
Why it is 14? It is written 14 in the FIR. He was not arrested on the same day.
No,
Your Honor, actually, he was,
he was,
as per the FIR, Your Honor, on the 23rd evening, on the scene, he has been on the PO, Your Honor. That means he was arrested on 23.
No.
But the case was registered on 24, Your Honor. As in the FIR also, it's reflected, Your Honor. On 23rd evening, around 8:55 p.m., the police IO had got information from sources and he sent two police personnel, Your Honor,
24/6/2025.
to the PO and arrested on around 2 a.m., Your Honor.
Fair enough. The line counsel for the petitioner submits that the accused is innocent of the allegations. According to you, he is only consumer. What do you say? What was your submission?
Yes, Your Honor. My submission is that the suspected,
Hmm.
Your Honor, contraband
Hmm.
has been seized
Hmm.
after, Your Honor, a prolonged search of, Your Honor, 6
Okay.
hours. So anyone could be kept that.
The-
So doubt,
It was
benefit of
all
doubt may be.
videographed. It was all videographed.
But Your Honor, and moreover, Your Honor, no seizure memo has been,
Suspected contraband.
there is no seizure memo in the FIR.
Sorry, it was seized after prolonged
That's why I'm submitting, Your Honor,
search
mandatory
For about
provision and guideline has been not complied.
hours.
Complainant, informant complainant is IO.
And
Investigating
informant,
officer is IO himself, Your Honor.
complainant. And IO, if the case is the same person. And then he has been, how long he has been?
It's been 52 days, Your Honor,
Okay.
now.
He
Till
has
today
been
is
in
52 days.
inside custody for about 50 days. And he is ready to abide by the, any terms and conditions to be imposed by the court. The Lane PP, the Lane PP vehemently object the grant of bail on the ground that the suspected contraband substances were recovered from his possession and he has indulged and involved in trafficking of the drugs and the matter is still under active investigation. See, further some is that the file for earlier, the bail application filed by the accused was rejected on merit on the ground that there is a potential for interference with evidence, and the evidence being tampered, or witnesses being intimidated as he is the teachers in the school. And the contraband seized was an intermediate quantity of drugs. Stuff and para. Hard borderline counsel for a petitioner. And as well as the additional people for the state staff. Considering the nature of allegation, the recovery of the contraband substances from the accused, which is intermediate quantity, and the stage of investigation, which is still under stage of investigation, and also considering the potential for tampering with the evidence. This court is not inclined to grant bail to the accused at this stage. Accordingly, the bail application stands rejected. Okay.
Yeah, my humble submission is that at least it may be, I may be give chance to take adjournment. It may be list after
Already rejected.
oblige.
Item number 7.
Yes, this is the one.
My lord, in this case, your lordship has seen yesterday the
Yes.
reasons for which I am praying for bail. My lord, the main accused, who is the ex-MLA, he was not arrested. Even now, he is at large. He is not being sought to be arrested by the police on the ground that the complaint has been withdrawn. My lord, the co-accused has been released on bail. Now, what has happened, my lord, there is no serious offense, as your lordship has seen. Now, apart from that, my lord, what your lordship has already seen, there is one more glaring thing which possibly I should point out to your lordship. In terms of section 47 of the BNSS, the grounds of arrest should be communicated. There are 2-3 judgments, one of which I'll just read out for a moment, my lord, to your lordship. My lordship may kindly have a look at page 22. I'll just show what they are doing about the communication of the grounds of arrest. Page 22. In the order passed by the learned JMFC, it has been mentioned, page 22, my lord, bottom paragraph. The IO also stated the grounds and reasons of arrest are also conveyed to Sri so-and-so, who is my counsel, my lord, in respect of both the accused person, and copy of arrest memo is also supplied to him. Next page, my lord. Further, it is stated in the arrest memo submitted with the forwarding report by the IO that grounds of arrest is for preventing the accused person from committing any further offense of similar nature, for proper investigation of the case, to prevent the accused person from causing the evidence of the offense to disappear, or tampering with such evidence in any manner, etc. I am of the considered view that grounds of arrest shown by the IO are cogent. Now, Lordship, the learned JMFC has made a serious error because, my lord, section 47, Lordship, may kindly have a look at section 47 of the BNSS. It says persons arrested to be informed of the grounds of arrest. Lordship is aware of that. Now, I'll just read 2 paragraphs from the judgment of my lord, 2024, volume 8, SSC, page 254, judgment by Honorable Justice Sandeep Mehta. And my learned friend will hand over a copy of the judgment to your lordship, my lord. Well, possibly learned court below has confused with the 2 expressions grounds of arrest and reasons for arrest. In the name of grounds of arrest, what are mentioned in this paragraph of the order passed by the JMFC, my lord, is akin to the reasons for arrest and not grounds of arrest which are sought to be which are required to be communicated. Lordship may kindly have a look at paragraph 48, my lord, at page 282. Paragraph 48, my lord. Lordship has got my paragraph 48.
Yes.
Para 48 says, my lord, it may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters, namely to prevent the accused person from committing any further offense, for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear, or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against the custodial demand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons for arrest, which are general in nature. Now, Lordship will kindly see paragraph my lord, 19. I'm sorry, 14, my lord, 14 of the judgment. Nineteen. I'm extremely sorry. It's 19 actually. I'm confusing.
Hmm?
Para 19, 19, at page 276.
19 of what?
This judgment, my lord. Here, my lord, almost Supreme Court has said what is the purpose of communicating the grounds of arrest, not the reasons for arrest. And I have shown the difference between grounds of arrest and reasons for arrest. Para 19 says, my lord, at page 276. Lordship has got my lord, para 19. Resultantly, there is no doubt in the mind of the
No. You are not
paragraph
audible.
19. My lord, paragraph 19, my lord.
Yes.
Paragraph 19 says, resultantly, there is no doubt in the mind of the court that any person arrested for allegation of a commission of offences under the provisions of UAPA or for that matter any other offence has a fundamental and a statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. The purpose of informing to the arrested person the grounds of arrest is salutary and sacrosanct, inasmuch as this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody, remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental right guaranteed under Article 22(1) of the Constitution of India. Now, as your Lordship has seen, the learned JMFC has confused about the difference between grounds of arrest and reasons for arrest. And the Honorable Supreme Court said, what is the purpose of communicating the grounds of arrest? And the communication of the reasons for arrest are formal. What is required is the communication of the grounds of arrest. And if this communication is not made, it is directly violating Article 22(1) of the Constitution of India. And that itself renders the arrest, my lord, absolutely illegal, and it has to be set aside only on this count, apart from the other ground that the, my lord, main accused has
You
not
have
been
not-
arrested.
not taken-
My lord? My lord, am I audible, my lord?
Yes, you have a scan copy.
Yeah.
Yes,
Yes.
okay. Copy of case.
Hmm?
Yes, Lordship, I have a scan copy case.
So what is the progress or
Lordship-
status of the
Yeah,
investigation?
Lordship, as per this, progress of the case, Lordship, the main accused, Lordship, he and his accomplice, Lordship, they have appeared before the IO and give their statement, Lordship. As per the Lordship, they have, they have found, Lordship,
Drawn
Lordship,
subsequently.
Lordship, in his statement, Lordship, the present Lordship accused name is not their Lordship. Only the
Okay.
main accused name is their Lordship.
The main accused name,
Yes,
MLS.
Yes, Lordship.
And whether has he stated that he wanted to withdraw, because he has already filed withdrawal petition before the eye of the case.
Lordship, in this statement, Lordship, the withdrawal portion is not been reflected, Lordship.
But we have already annexed, my lord, that withdrawal letters.
Try to just prevent, Lordship, that
Okay.
Yes, on
The
the,
co-accused has already been released.
lordship, all are already released, lordship. One is co-accused is released, lordship. His statement is there, lordship, and the main the accused which is under custody is the only one, lordship. And rest of the main accused also released and give. He has never arrested, lordship. The main accused.
Main accused never been
No, lordship.
arrested.
He's only appeared before the and give his statement.
So that since the accused, main accused has not yet been not been arrested,
No, no,
and the co-accused has already been released.
lordship.
What is the injury report? Injury is it
The injury is simple, lordship. As per the
Simple.
investigation, yes, lordship.
then can be granted
Lordship, it can be
on
lordship because
parity?
yes, lordship, yes.
And
Lordship.
the main accused has never been arrested.
No, lordship. He
On
only
that ground, he can be released.
And I'm a young lawyer, my lord. I'm suffering in the jail for last 50 days.
PP for a state.
And this time it's cloudy today.
This petition under section 483 of the Bharatiya Nagarik Suraksa Sanhita 2023 has been filed by the petitioner for seeking grant of bail to the accused, the Okto Mangnam, who has been arrested in connection with the PS case number 97. Stop. This is a successive bail application filed. A successive bail application. Filed before the judicial magistrate, the magistrate first class was rejected. But leave that. Was rejected on the ground that the accused was clearly visible in the CCTV footage entering the office of the informant along with other co-accused persons. The second bail application was also rejected by the second bail application. Of the CCTV system. The third bail application filed before this court was rejected on the ground that the accused was found involved in the case and he has not taken any new circumstances. The petitioner contends that the rejection of the this present petition, the petitioner placed reliance on the judgment of the Supreme Court in Hari Singh Man versus Harbhajan Singh Bajwa, reported in 2001, 1 SCC 169. With no new circumstances in the successive bail application amount to review of the earlier the review of amount to review, which is impermissible under criminal law. The and named accused in the FIR has never been arrested. The co-accused who is alleged to have involved in the case has been enlarged on bail.
And my statement has been recorded under section 180, madam, already.
Has been inside the custody.
Since 26/6, madam.
Around 50 days. He has been
Yes, yes.
inside the custody for more than
3 days, Lordship.
peruse the record. So reveals that the
In the statement of the complainant, his name was not real, Lordship.
the statement of the complainant was recorded. Just a minute. In the statement of the informant, the name of the present accused, he has not taken the name of the present accused for the record also reveals that the informant has already withdrawn, has filed an application before the eye of the case for withdrawal of his FIR, withdrawal of FIR. The accused and the main accused, the MLA against whom the FIR has been lodged, has not been arrested. He Both the Islamic Council party. Proper. Considering the fact and circumstances of the case that the name accused persons MLA has not been arrested, comma, the co-accused involved in the case has already been enlarged on bail, and the injury sustained by the accused is minor injury, and that, and also considering that the accused, sorry, is submitted by the Land Council for the Land Additional PP. And as he is cooperating, and as he has already given statement and cooperating with the eye of the case, comma, this bail application, this bail prayer, this bail prayer for release of the accused is allowed. Stop. The accused is directed to be released on bail on execution of a bail bond of rupees 20,000 with 2 sureties of like amount to the satisfaction of the he shall not or tamper with the evidence of the case in any manner, that he shall not leave the jurisdiction of the court without permission of permission should be from IO or court,
Lordship,
Let it be IO, my lord.
prior permission of the IO.
My lord.
Okay.
Connectivity is real problem.
Okay, the co-accused, and Anthony
Pabin,
has been released, co-accused names,
Yes.
considering and on parity also, okay?
Yeah.
And thereafter, after this court has been released, this court is of the opinion that on parity, Okay.
obliged.
Obliged.
Item number 8.
May I beg your lordship? Pre-arrest bail application.
Yes,
My lordship,
you have received
CD was called.
CD.
Yes, prior to that, your lordship, I'll just like to apprise your lordship that in item number 9, item number 9 and 11, your lordship, this matter has been handed over to the SIT, your lordship.
Okay. But, okay, this is different case, separate case or what?
No, your lordship, if I may, your lordship. Offense is same, your lordship. 2 FIRs are registered in this case.
Okay,
Item number 8, 9 and 10 and 11. Now on 9 and item number 9 and 11, it seems the SIT is taking up the investigation. Same offense, 2 complaints, 2 FIRs.
okay. So, you have received,
Yes.
is there any
In
material?
item number 41, your lordship, there are ingredients, there are witnesses for PS case number 41, your lordship.
Item number 8.
8.
Yes, Your Lordship.
What is there?
There are witnesses who has witnessed the presence of the accused, both
Okay.
in item number 8 and 10, Your Lordship.
Mhm.
Also, there is a statement by the IO that even the CDR, which was a DVR, which was in the custody of the police, Your Lordship, they had intentionally taken out the DVR of the CCTV, Your Lordship. That allegation is also there. We are yet to retrieve the DVR, Your Lordship. And there are independent witnesses who had come to the police station for some other purposes and also in the medical. All those witnesses has also taken the name that they have seen the
Okay.
person.
So they are the eyewitness
Yes,
to the
yes.
incident.
Yes,
So they have given their statement.
yes, Your Lordship. Also, Your Lordship will see the FIR itself states that there were 500 to 600 people. The mob was there, Your Lordship, and
They led the move.
they led the mob. Now we
They
are
are from
also
the FIR.
yes. The other CCTV, which was not directly facing to the entrance, Your Lordship, those CCTVs DVR has been retrieved. Some of the faces are recognized, which some of them has been arrested. Till date, Your Lordship will see 5 of the accused has been arrested, Your Lordship. One of the accused has also given a statement that he was involved. Your
Taking their
Lordship.
name.
Yes, Your Lordship. Now we are yet to question many of the witnesses also, Your Lordship, who was at present, Your Lordship. Since this incident consists of a large mob, Your Lordship, at least the investigation will take time, Your Lordship.
This FIR was filed by the inspector himself.
Yes, Your
Yes.
Lordship.
So CCTV, this footage has not yet been recovered,
Yes.
but then other CCTV.
Other
from
CCTV from
can
other,
be-
even
it is
from the
clearly visible.
CCTV of the medical, Your Lordship, because the deceased was taken to the minor OT in the hospital of the particular district, Your Lordship. From there, that's the place. First, they came to the police station. From there, the police has escorted the deceased to the medical, Your Lordship. In the medical, the mob entered, broke the lock, and took the deceased to the main road and lynched him, Your Lordship. At this stage, Your Lordship, if I may, since more particularly both the applicants in item number 8 as well as in item number 10, Your Lordship, their presence has been very much corroborated by other witnesses, including independent witnesses, Your Lordship. At this stage, this is a very early stage of investigation, Your Lordship.
So, yes, this, I think this, the accused in item 8 and 9 are same.
Yes, 10 and
10
11
11 are
are
same.
same, Your Lordship.
That means all the same.
In item number 8 and 10, Your Lordship,
Hmm.
the FIR was first registered. The accused the applicant in item number 8 and 9, his name has been reflected in the FIR, which is PS 41, Your Lordship.
So this 8 and 9 means 10 and 11.
There are two FIRs, Your Lordship.
Yes.
One is filed where his name is there, Your Lordship.
Hmm.
Subsequently, another FIR was filed where the name of some other more people who were involved are reflected in the second FIR, Your Lordship.
So, two different FIR.
Of same
Even
offense.
Which FIR is being investigated by sent to SIT?
yes,
Which
The
FIR?
second FIR.
second FIR
One, where
PS
where the
40
name of
case
the
number
accused persons are reflected.
reflected, Your Lordship. In the first FIR, only the name of the applicant in item number 8 and 9 is reflected. Even in the
Okay, so but in the 10 and 11, it is clearly reflected.
reflected, Your Lordship.
And in 8 and 9 also, okay.
In 8
that is
and
fine, that is-
furthermore, in 8 and 10, the sections given are of 4 sections, Your Lordship, including PDPP Act, Your Lordship. In the second FIR, which is item number 9 and 11, there are sections reflecting murder, assault, grievous hurt, rioting, and unlawful assembly, including the PDPP Act, Your Lordship.
Your Lordship, item number 8, Your Lordship, the first FIR. All the sections are valuable in nature except for section 3 of PDPP Act, Your Lordship.
So what is section 3?
This is causing damage to public property, Your Lordship. Punishment, Your Lordship, is 5 years.
So in item number 8, this actually it was a move list.
Mob
Oh,
lynch.
Item number 8, Your Lordship, in FIR number 41, Your
But
Lordship.
then but the
Allegation is
Hmm.
allegation is leading a mob, Your Lordship.
And 10 and 9.
9, Your Lordship, they have subsequently, Your Lordship, they have added the sections saying that the mob had lynched the
No,
deceased,
Your Lordship, item number, if Your Lordship take up item number 8 and item number 9 simultaneously. Item number 8, the FIR is at page number 14.
Both applications, Your Lordship, page number 14, Your Lordship. Entire contents of the FIR is same. Only one paragraph is added consisting of seven lines approximately, wherein the names of some accused persons are reflected, Your Lordship.
14 is the first FIR.
14 is the
Page number 14.
First FIR.
this is an FIR when the deceased has those assaulted, Your Lordship. He was just he had gone into unconscious state, Your Lordship. Subsequently, due to such an assault, Your Lordship, he expired, which is in item
On the
number-
same day.
same day, Your Lordship.
But then this was
Your
lost.
Lordship will, Your Lordship
This
will
was
see-
lost before his death.
This
Yes,
was
sir.
this was not before his death. Therefore, the section of murder was also not included, Your Lordship. Your Lordship will see the first FIR was filed at around 1850 hours. And the second FIR is at 19 hours. Within 45 minutes of when he was assaulted, Your Lordship, he expired.
No, after lodging of this FIR, because at the time of lodging this first FIR, probably he was still
He
alive.
was alive.
He was
And
only
then
the
subsequently he died, and then the
Yes,
second
yes.
FIR.
Yes,
Yes.
Your Lordship.
Okay. Mr.
T. Sering, Your Lordship.
T. Sering, learned counsel for the petitioner. I've also heard Mr. Jeannie, learned additional PP for the state. Para. By filing this application under section 482 of Bharatiya Nagrik Suraksha Sanhita 2023, the accused petitioner seek pre-arrest bail, apprehending his arrest in connection with drawing PS case number 41 stroke 2025 under section 62 within bracket 2 stroke 117 within bracket 4 stroke 191 within bracket 2 BNA with section 3 of PDPP Act. The allegation against the accused is that he led the move forcibly entered the police station, took out the damaged the furnitures and other properties of the police station, took out the accused from the police custody, and have him move lynched. According to accordingly, the FIR filed by the director of the concerned police station was registered being drawing PS case number 41/2025 under section same, same. After damage the property, after damage the furniture and the property, After that, furniture and the property, comma, CCTV. Okay. That will do. Okay. Fair. So what is your submission, Mr.?
My lord, since in the first FIR, your lordship, the disease was very much alive, and the sections which were under which the FIR was registered, your lordship, most of the sections are available in nature, your lordship,
Okay.
except section 3, your lordship.
Okay.
But on the face of the FIR, your lordship,
Okay.
it doesn't that I was the one who has vandalized, or I was the one who has taken out the CCTV, and I was the one who has taken the DVR, your lordship. Nothing has been stated in the FIR, your lordship.
Okay.
And moreover, your
So,
lordship, there are people of alleged people of 500 to 600, your lordship.
The learned counsel for the petition, the learned PP, while referring to the record, submits that subsequently the took out would be that accused in another case, the accused from the custody, accused, and then submission would be the while referring to the record, submits that subsequently the mob constituted by the accused person has lynched the accused in another case to leading to his death. Leading to his death. Stop. Leading to his death, and the same police has filed FIR, second FIR.
Same.
And after the death of the deceased, the inspector of the concerned police station loads second FIR, giving the name of the, whereby he has also given the name of the other co-accused persons, and also stated that the accused has been lynched too. Stop. The learned counsel for the petitioner submits that in the first FIR, except for the Section 3 of PDPP Act,
Yes.
all other offenses registered against the accused are bailable offenses.
Available.
Stop.
And the FIR also, your lordship, it doesn't state my name that I have vandalized and I have vandalized the police station or the CCTV or I have taken the DVR, your lordship, of that police station.
So, okay.
So section 3 also basically, your lordship, it seems that to understanding, your lordship, is that section 3 also doesn't attract in my case, your lordship, in FIR number 41 of 2025, your lordship.
While admitting that you have committed all these, according to you, it doesn't attract.
No, your lordship. It only
The
says, your lordship, it says that I have led the mob. However, doesn't say that I have vandalized.
Okay. And
It's the mob, your lordship. That's why I'm saying that there is a mob of 500 to 600
Okay.
people, your lordship. Anyone can.
and further submits that although there is an allegation that he has led the mob of around 500 to 600, vandalized the police station, took out the CCTV footage and the DVR from the damaged the furniture, took out the CCTV and DVR from the police station. However, your submission is that you have not done that.
No, your lordship. No, your lordship.
Although there
There are allegations, your lordship, that mob was led by me, your lordship.
Okay.
But the FIR doesn't say that I have done this thing, Your Lordship, that I have vandalized, Your Lordship. The mere allegations, Your Lordship.
Mere allegation.
Yes, Your Lordship.
The above are allegation, and he is innocent of the allegation.
Yes, Your
Okay.
Lordship.
Staff, peruse heard the learned counsel for the parties. Also peruse the record. Staff, considering the nature and the seriousness of the allegation against the accused person, comma, role of the accused petitioner leading the mob to the police station, vandalizing the police station, comma, destruction of the furniture, taking out CCTV, DVR, and also considering the material against him supported by the statement of the witnesses, corroborated by the statement of the witnesses. This court is of the opinion that a custodial interrogation of the petitioner may be necessary for effective investigation of the case. Stop. Under the circumstances, grant of anticipatory bail. Grant of anticipatory bail in such circumstances is likely to hamper the further proper investigation of the case. Accordingly, this application is rejected. Okay. So this will be same, little bit of correction number, okay, and then a section also. Section also is all the same because FIR is same. Only in the second FIR, inclusion of the
Medical part.
Incident, Your
state
Lordship,
part.
has been extended and some sections are added, Your Lordship.
So
The
this,
subsequent
okay, in the second
page number 14, Your Lordship.
rowing PS case number, second is rowing PS case number 42. 42. So, this was PS case number was, first was
41.
41. This is 42, huh? 42 stroke 2025 under section 103, 103 within bracket 1 stroke 103 within bracket 2 stroke 132 within stroke 61 within bracket 2 stroke 333 stroke 190 stroke 190 within bracket stroke 191 within bracket 2 BNS read with section 3 of PDPP Act. Okay. And in the yes, and in item 10 and 8 would be same.
Yes.
Your lordship, here grounds are different.
But arising out of the same.
Yes,
Same FIR.
same.
What ground?
The same. Here, I am pregnant. I'm 5 months pregnant. So which I had enclosed.
Okay, and in his submission, we further submits that the accused applicant is a pregnant woman. Okay, and what else?
Because I'm 5 months pregnant.
5 months pregnant. Huh?
Yes. So I would like to look at the citations wherein it says that may I come to section 480 of BNSS.
See, because here I have dictated is that interrogation would be necessary. just appear before the police. And immediately, because for recording of a statement, it won't take much time, say 1 day. Okay, since he is a lady, she is a lady, pregnant, the police will take care of it. And then immediately file bail application, and on the other side that 494 earlier 437 also in the earlier CRPC, she is entitled. But then under the circumstances, in the present case, so her statement would be absolutely necessary, what we feel.
In that case, this may be reflected. In case of arrest, her bail should be taken as in priority.
Okay, and then after rejection, bail after rejection, if in the lady, so the petitioner is given liberty to approach the trial court for regular bail.
Yes.
Regular bail. On such bail, regular bail application, if on filing such bail application, the trial court shall consider the bail in accordance with law. Okay, in accordance with law would be that. Okay. Yes. Okay.
Because there are certain
And-
petitions and all, which
And then the second also, if the lady in the
Same.
Emily Lingi, so these contents will be same, and the number will be the 9 and 11 are same.
But in my country, I want to submit further here because FIR 41 and 42, the time period of the offense is the same. So there cannot be two FIR.
No, the offense is same, but then one is lost mentioning the person and as well as the date of the person.
No, Your Honor, the time period of the offense.
Just clarify that, Your Lordship.
That
First, he was taken into the custody, arrested, Your Lordship. The mob came and attacked, Your Lordship. To protect the deceased, Your Lordship, he was taken to the medical. So when the mob attacked the police station, that was when the 41 was lodged. Subsequently, he was taken to the medical, Your Lordship, and he was closed in the OT, minor OT room, Your Lordship. The mob followed the deceased and came to the medical. They have even destroyed the properties in the medical, Your Lordship.
Medical also.
Medical, that is the second FIR,
Okay.
42. So the place of occurrence is different, though it follows from the same,
But it
Sets of-
continues from the first FIR.
it continues from the
Okay.
first FIR. First FIR reflects with
Then in
regard
second
to,
FIR, one line, second FIR, after the destruction of all those, destruction of the police station, and then they have also destroyed. Medical, what thing was destroyed?
if I may just read that particular sentence, Your Lordship, I'll just read. Somehow the police team managed to rescue the victim from the mob, and considering his deteriorating physical condition, he was taken to the nearest district hospital, Roy, for medical examination. The victim was admitted to the hospital emergency room. However, the same crowd again barged into the
Okay.
medical and vandalized the medical property.
Okay,
and
the moves also followed the, when the accused was taken to hospital, nearest hospital for his safety, for his treatment and safety, the move followed, and there where they also where they have vandalized the okay, hospital also. Okay, vandalized the hospital and vandalized the hospital and damaged the property.
Yes.
Okay,
Deep.
that is in 9 and 11. Okay.
Deep.
Matter number 12.
Yeah.
Fix in admission column.
Mr.
Yeah,
Planning Council for the, you are for the petitioner.
yeah. No, I am for the respondent.
For respondent, who is for the petitioner here? The Planning Council for the party. So record, okay, Planning Council for the parties are present. Record also received. Let this matter be placed. Let the matter be listed for admission. Okay, after 3 weeks.
Item number 13.
Since the parties are duly represented, let this matter be listed for admission after review. Okay.
Your Lordship, this matter is listed as a in order column.
Yeah.
This matter will kindly taken as a hearing matter, Lordship. As TCR is available, I think. In this
Okay.
case.
You are Mr.
Bitaba.
Bitara.
Bitaba.
Lane counsel for the petition. You are for the petitioner.
Yes, petitioner. We can go for hearing also.
This is for what?
For orders, order in column.
No, other, but then what is this petition of?
This is a criminal petition, joint petition also.
Joint petition.
Yes.
Record is also there. Record is there. What is the section involved, offense involved?
Regarding 392, robbery, this is not compoundable in nature also.
What is this 392?
This is
Rob,
robbery,
robbery,
yes.
323. Robbery, what robbery? Robbing of what?
You may, if in FIR also, I will go, may I kindly read the FIR. At around 12 a.m., some unidentified miscreant assaulted me while I was walking to rented room from my office to the Arunachal Times near Secretariat bus stand. 2 of our 4 guys seems to be drunk. They attacked me and snatched away my belongings.
Okay.
After
So that was, whether that was recovered?
that was,
You said this is joint petition.
yes, joint petition, and there was charge sheet was booked for the 4 accused person.
Just a minute. Just a minute. Let us see if we can dispose of
On settlement also.
robbing settlement.
Yes.
Whether the item was recovered, the articles.
There is one Jima Nama
Okay.
in 30
Where?
page
Where?
number
Where?
35.
Page number?
35.
Yes.
Yes.
And a mobile number,
Samsung.
so recovered.
Hmm.
And where in the,
Charge sheet also.
no, just a minute. Where is the FIR?
Fire is in page number
Okay.
Nine.
FIR.
19.
Okay.
And the
Charge
next
sheet is? Where is the charge sheet?
charge is in page number 20. Total, there was 4 accused person,
Okay.
and one of the
Charge
accused,
sheet File against how many accused?
4 accused person, and accused number 3 is expired.
Accused number 3 is.
3 is expired. I have annexed the death certificate. It's in page number 38.
Okay, in the petition, 1, 2, 3.
Three petitioner are there.
three
They are
petition.
the
One is who expired,
alleged accused number 3.
namely?
Namely Tanya Tamar.
Tanya Tamar.
Tanya Tamar.
During the pendency of the case.
Tanya.
Okay. Whether the court has taken cognizance. Court has taken cognizance of the case.
Yes, in the stage of appearance, which was stayed by the Senate.
Where is the court order? Page 37.
37. This is the bail order.
This is the bail order.
Yes.
No, this is bail order. Where is the GR case? Where? There's no GR case here. GR case number. So where is the appearance order? Have you annexed?
Appearance order, I have not annexed. I have annexed the bail order. It's there in GR number 408 of 17.
Bail was rejected or granted? Bail was granted.
Yes, admitted for hearing.
Hmm?
It was admitted and CD was called for it at that time.
All the accused persons are named in the agreement, settlement.
Yes, except the person who is expired, and the rest 3 of the accused person are there, and the informant, including the informant
Yeah.
person.
Two,
Informant is
3.
this Ranjit Sinha.
Okay, when the incident took place, 2017? Or when the incident took place, 2017? 7-year-old case.
Lordship,
7/7/2017.
Lordship, here Lordship, little confusion, Lordship, that Tanya
Yes.
Tamar,
He,
Lordship, he,
expired.
no, yes, Lordship, but in the charge sheet, Tanya Raja is there, Lordship, name is different, Lordship.
Name is different,
Yes, Lordship, but father name is same.
same.
Yes, father name is same, but name is different, I think. But in their settlement agreement, also page 42, where they have mentioned that Tanya Raja at Tanya Tamar.
Then it's fine.
Yes.
Okay. So I think we can dispose of it.
Yes,
It's only
Lordship, on
just-
all case,
Okay.
Lordship. Yes, Lordship.
So you,
Mr.
Bitaba.
B,
B for ball.
okay, B,
Taba.
Taba.
Ah.
This is item
13.
13. B, Taba. B, Taba, your name is there. Okay.
Yes.
Hard Mr. B, Taba. Not happy for the petition. Also hard Mr. Yeah, and again, landed. Petition of PP. This this joint application has been filed under section 5(2)(a) of the BNSS 2023, seeking quashing, and filed 2028 by the accused and by the informant and the accused persons in seeking quashing and quashing of the proceeding in GR case number 404/17 arising out of ITA PS case number 169
You said this is for reliance of the case.
2017 under section 392/323/34 of IPC pending before the Court of Judicial Magistrates First Class Capital Complex, UPIA. What is this?
On settlement of Lakshmi Narayan case.
Okay. Para. The petitioner number, who is the informant?
Informant is Ranjit Sinha.
Informant is Ranjit Sinha. The
Victim
petitioner number 1, 2, 3,
4 is the
the accused, and the petitioner number 4 is the informant in the above GR case number 404/17 arising out of ITA PS case number 169/2017. Stop. The petitioner, the fourth accused in the above PS case, Tanya Tamar. Tanya Tamar, alias? Please, submit it. Tanya Tamar, alias?
Tanya
Where it is
Raja,
mentioned?
like,
it's in
Tanya Raja, alias Tamar,
page 42.
passed away. So, passed away during the pendency of this. Okay, during the pendency of the investigation. Investigation only, I think, because he expired in 2017. Where is the,
Page 38.
that is the, when it was lost?
When was vote?
7/7/2017.
Yes, and then this person has expired on
So
26.
26/10/2017, on the same year.
And then charge sheet filed on, let us
Charge
see,
Charge sheet filed on 26/8/2017.
oh no, after filing, I think, during the pendency of this case, huh?
Yes.
Stop, huh? Para. The prosecution case leading to the filing of this petition is that on 7/7/2017, the petitioner number 4 lodged FIR before the OCPS Itanagar alleging whether there were known persons, okay, alleging that 4 persons had robbed him of his belongings, including wallet, ATM, between bracket SBI ATM card, PAN card, cash amount of rupees 4,000, driving license, registration card of the bike, government accreditation card, office ID, etc. Based on the above affair, the aforementioned police station case was registered and investigated into. Upon completion of the investigation, the police has submitted charge sheet against 4 accused persons, including the accused petitioner number 1, 2, 3, and the deceased Tanya Raja alias Kamar, and one Sri Tanya Raja alias Kamar since within bracket since deceased for offense under section
392.
392,
323.
323, 34 IPC. Stop. Para. It is submitted. Sorry. When the magistrate had issued process, when it was
12/7/2017.
what?
It's the bail order.
Okay, bail order. Okay. It is it is submitted that during the pendency of the case, the parties have amicably settled the matter by executing a settlement deed on 30/9/2024, whereby the it is stated that whereby it contained that immediately after lodging of the FIR, the informant petitioner number 4 has received, recovered and received his stolen item, including stolen item, recovered and received his all the stolen item and received stolen item in Jimma, in Jimma. Stop. The agreement further contained that the informant has forgiven the accused persons for their mistakes, and since the matter has amicably been settled, he have no further grievances against the accused petitioner number 1, 2, and 3, and he does not wish to pursue with the matter any further. Stop. The para, the learned additional PP fairly submits that since the matter has already been, the matter has amicably been settled between the parties, since the matter which has been pending since 2017 has amicably been settled, and the informant has received back his all belongings and does not have any further grievances, and also does not want to pursue with the matter. She has no objection if the petitioner is allowed. If the present petition is allowed. Stop. Para. The land council for the party. I've also perused the report. Upon hearing the parties and considering that the accused, that the informant has received back his all the stolen items comma, the matter is of the matter is an old case of year 2017, comma, the parties have amicably settled the matter, and also considering that the matter involves with the individuals as does not affect the society at large. This court is of the opinion that under the circumstances, the further proceeding of the case against the accused person would be a futile exercise and an abuse of the process, as there is no chance of any conviction in the case. Stop. The Honorable Supreme Court in
State of Madhya Pradesh versus Lakshmi Narayan.
case in state of Madhya Pradesh versus Lakshminarayan and others, reported in 2019, 5 SCC 688, and in many other cases. This paragraph,
Paragraph from 15 to 18. That's the relevant.
many other cases decided. The High Court, in exercise of power under 482 of the Code, can quash the criminal proceedings for the even for the non-compoundable offenses. Where which are private in nature and do not have the serious impact on society, on the ground that there is a settlement stroke compromise between the victim and the offender. In view of the above, in light of the above, the this court of the view that the present petition can be allowed. So accordingly, the petition is accordingly the petition is allowed. In the same paragraph, the petition is allowed. Accordingly, the proceeding of the proceeding in GR case GR number 40417 arising out of Utah PS case number 169 2017 under section 392 323 34 IPC pending before the Court of the Judicial Magistrates First Class Capital Complex UPR against the accused Gokia Nehru, Yorda Sanjay, and Joram Tadam is hereby first. In the interest of justice. Stop. With the above, this petition stands disposed.
Obliged.
Are why you did not inform? We'll continue at 2:10. Please. Yes.
My lord, here, quashing petition on the basis of settlement arrived between the parties. The dispute is alleging offenses of 324 IPC punishment is extended to 3 years or fine or both. And the dispute initially arising out of completely civil dispute and which is private dispute nature. The FIR I have annexed in my petition, page number 12, is arising it which is connection with the land dispute. Out of land dispute, there were some scuffle between the accused person, accused petitioner, and the victim. And as such, some minor injury was received on victim. And in a result, FIR was filed before the OCPS 0 and OCP 0 PS case number 107 2016 under section 226 307 IPC was registered. But during the time of framing charge, 324 IPC was framed. With the page annex in the page number.
Charge also framed.
Yes, charge of the frame. The case is on the trial stage, the evidence stage. And I have annexed the page number that the latest order, trial court order, page number 14, annexure 4. The last date of hearing was on 3/7/2025, but due to PO in absence, the matter could not conducted by before the learned trial court below. Now, in the meantime, the page number 16, annexure 5, the settlement arrived between the parties.
Where is the charge sheet?
My lord, charge sheet I have not annexed in my FIR, in my petition. Moreover, I have annexed that proceeding, day-to-day proceeding order, page number 15. The stage of the case pending before the learned trial
No,
court.
where is charge framed order?
Charge frame, page number 14. Page number 14. Annexure 3.
Page number 14 is something else.
Uh,
Okay, this is charged with one head. This is,
handwriting, yes. Annexure 3.
oh, this is before magistrate,
Yes, before magistrate.
chief judicial magistrate.
0. And from the daily order sheet also, page number 15, here also LI section is reflected as 324 IPC only. So my humble prayer before this humble court is that since the party is residing in the same locality and
What is this IA?
the yeah, that is one as per direction of this humble court. And the last occasion, the victim was directed to file the affidavit, saying that he knows such objection for quashing the
The victim is,
petition.
victim is a joint petition.
Yes, in the joint petition, accused petitioner and the informant was jointly filed. And in the meantime, the last occasion, the humble court find that the victim has to be implicated in this case. Therefore, the humble court was pleased to directed.
What is the name of the victim?
Lisa
Okay,
Peg.
victim was not impleaded earlier.
Yes,
Okay, now victim has been impleaded.
impleaded and also filed a no objection affidavit.
Who is, you are representing the victim, where is that? Where is your affidavit?
The IA, Your Honor.
IA is your affidavit. Okay. Okay. Yes, Lana PP, have objection?
No, Your Lordship.
24?
It's only 324, Your Lordship.
Yeah.
307 was dropped and 326 was also dropped. Okay. Except for the report on the earlier occasion, my concern was that since DW 5 was also, it was in the last stage of defense witness examination. However, it seems that due to the order of stay, if I'm not wrong, Your Lordship, the matter has been stayed otherwise.
Where the record was told for,
The record is yet to be received by the registry. Your Lordship.
yet to receive. What do we do?
Your Lordship, since the defense witnesses has also not been completed, Your Lordship can dispose of this matter otherwise, because if it was in the stage of final hearing,
So that means there was a material, I think.
I think,
That is why
Yeah.
they have,
yes.
okay.
But then since the offense is of not serious nature, and even if it was at the stage of 313 or at the stage of final hearing, I would may have made my objection with regard to Narayan Singh's case, Lakshmi Narayan Singh's case. However, even the defense witnesses examination has not been completed, and since the offense is also not of serious nature, Your Lordship.
Mr. Tito, Lana Council for the petition. I have also had Ms. Eugenie, Lana Edison PP for the state, and Mr. A for appearing on behalf of victim. Staff, Para. This application under section 528 of Bharatiya Nagarik Suraksha Samhita 2022 has been filed. No, this is a joint application, This joint application under section 528 of Bharatiya Nagarik Suraksha Samhita 2023 has been filed by the accused, informant, and the victim.
No, Your Lordship, it was filed by the informant and the accused. On the
Okay,
later stage,
okay.
victim was-
Informant and the accused seeking quashing of the GR case number 164/2016 arising out of which PS case?
Zero PS case number
Zero PS case number 107/2016
2016.
under section 324 IPC.
Your Lordship, if I may just correct Your Lordship, the FIR was registered under 326 and 307 IPC.
Is it?
Yes. On the later stage during the
Okay, 326 and
307.
307. That is why you should have actually annexed the charge sheet.
Exactly.
What?
So the framing.
So don't do half-heartedly and then trying to avoid 326. It appears. Don't do that. Never do that. Anything, everything, whatever is relevant to the case, you annex everything, excluding nothing, included.
I agree. Polite.
Don't do that, It doesn't look nice. Which you know that is a required, that necessary, and then you have not included. The prosecution case leading to the filing of this application is that on 27/12/2016. It's a 2016 case.
2016 case.
2016. The petitioner, the informant, stroke petitioner number. Informant is petitioner number
1, Your Lordship.
1. Lodged an FIR before the officer in charge, police station 0. Inter alia alleging. They are in that. Alleging the accused applicant number, accused petitioner number 2, 4, commission of offense under section 326 stroke 307. No, register is different again.
It's it was registered under 306, 326 and 307.
326 stroke 307 of Indian Penal Code. The case was investigated into, and upon, just a minute. No, okay, the case, the case was investigated into, and upon completion of investigation, the IO of the case submitted charge sheet against the accused for offense under section 324 IPC. The learned judicial magistrate, upon taking cognizance of the case, has framed charge against the accused under section 324 IPC. Stop. The case is still under trial proceedings. No, sorry, the trial proceeding of the case is now at the stage of, okay, the case is still under trial proceeding before the learned judicial magistrate first class 0. Stop. Para.
Chief Judicial Magistrate.
Chief Judicial Magistrate 0, not Chief Judicial Magistrate. Stop. Para. It is, the learned counsel for the petitioner submits that during the pendency of the learned counsel for the petitioner submits that in the meantime, the matter has been amicably settled between the parties. By executing a settlement agreement on 28/5/2025. Here in the settlement agreement, the victim is not the party.
He is a party, Your Lordship.
Oh, she's a party. Okay. The victim has also been made as a party to the settlement agreement. Stop. It is submitted that the complaint, sorry, the FIR was lodged against the accused petitioner number 2 by the petitioner number 1. The 1 is the informant.
Yes, yes, Your Lord.
1 for assaulting the victim due to misunderstanding with regards to the land dispute where some altercation took place during the assessment of highway compensation leading to filing of FIR. No, so leading to submission of charge sheet against the accused. Petitioner number 2, stop. However, since the matter has amicably been settled, the informant expressed that he has no further grievances against the accused petitioner, and he does not want to, the informant and the victim express that they do not want to, they no longer have any grievance against the accused and does not want to pursue with the matter any further. They also expressly stated that they will cooperate with the accused for compounding of the case before the Chief Judicial, before the court by filing joint petition. Cooperate for the compounding of the case by filing joint petition before the High Court. Start. Para. The victim, the victim has not been made as a impleaded and not been made as a respondent party or nor filed joint petition along with the accused and the informant. However, by filing IA within bracket criminal 81 AP 2025, the victim has stated that since the matter has amicably been settled, she does not, she or he does not have any further grievance against the accused. And he also does not want to pursue with the matter any further. Next para. Ms. T. Jeannie Leonard Edison PP fairly submitted that since the party has amicably settled the matter during the pendency of the trial proceeding and the allegation against the accused is also not very serious, therefore, she has no objection if the petition is allowed. Stop. Had learned counsel for the parties and also peruse the available record. Stop on para. Considering that the parties have amicably settled the matter and settled the matter by executing a settlement deed, and also considering that the offense alleged against the accused is not very serious and it does not affect the society at large, society at large. This court is of the opinion that the matter, so the proceeding against the accused before the trial court, sorry, the petition filed by the petition, this joint petition can be allowed in the interest of justice. Stop. No, between these, and under the between these, one sentence ahead. Under the circumstances, there is a remote chance of conviction of the accused. There is a remote chance of conviction with the accused. And in such and as such, the in such by allowing the trial proceeding against the accused would amount to abuse of the process of law. In view of the above, this court is of the opinion that the joint petition filed by the accused, informant, and the victim can be allowed. Accordingly, this petition is allowed. Oh, one more sentence, I have to put the Supreme Court judgment. You have also given some judgment, no?
No, that was only Lakshmi Narayan's case. Your Lordship.
Okay, let me know. Okay, then, the Supreme Court in such cases has also, in such cases, the Honorable Supreme Court has also in Lakshmi Narayan and many other cases has held that the High Court in exercise of the power under Section 482 within bracket corresponding to the 5 to 8 of BNSS bracket clause can first can compound the non-compoundable offenses if the parties have settled and it does not affect the society at large. Okay. Okay, then come back in view of the above, the accordingly, the proceeding in GR case. What was the GR case? 164. 164. GR case number 164 arising out of 0 PS case number 107 2016 under section 324. See, Dharam, you have wrongly mentioned this is FIR is not only 324. It is FIR is 326 and 307. See, don't try to be smart. It doesn't look nice. You have concealed it. FIR is not that what you have written here.
The document transferred from the friend who reside in the zero. So accordingly, I follow with that document, whatever they.
Yeah, don't do that because FIR is 326 and 307 only. You have written 24 only. This is suppression of the fact.
As per charge sheet, follow as initially.
No, you have not analyzed the charge sheet also.
Yes.
Although the charge is framed only after hearing the parties. Hearing is on 326 and 307 only. After considering it has come down to 327, 24. That is different. But you should have mentioned here. You should have written here entire fact. See, this doesn't impress the court. Will never impress the court. Court will have negative impression against you. You are trying to suppress the material. Don't do that. It will go against you. Never try even a smallest of the small thing also. Take care of. Be truthful.
Apologize for that.
Not impressed. Huh? Okay. We are arising out of so and so. Pending before the Chief Judicial Magistrate, 0 against. What is the name of the accused?
This is same.
This is same. Be hereby quashed for the interest of justice. Stop. Huh? With the above this criminal petition stands disposal. The IA, huh? In view of the order passed in the criminal petition, the IA stands disposal. Okay. IA had whether IA is also in listed. Yes.
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 Yes. Okay.
I know.
Item number 15.
Lordship, this is a joint petition filed by the alleged accused and the complainant.
This is also joint petition.
Yes.
Okay. What is the?
Here, Your Lordship, it's a joint petition, no doubt, but Your Lordship, the matter is at investigation stage.
Oh, this is
So-
FIR
Yes, Your Lordship.
against quashing of FIR.
Yes, your lord. It's a settlement, no doubt, your lordship, they have settled the matter. And your lordship, so far as the record is concerned, I have gone through the settlement also. But your lordship, my only concern is regarding your lordship, the perusal of the case diary. But we have not received the case diary. For that, your lordship, I would pray that the case diary, court may await for the case diary. Your lordship.
You call for the case diary. Okay. We'll peruse and it will be allowed only. Let us see.
Yes,
What is the,
exactly.
by the way, what is the offense? What is the offense alleged against the accused?
118, previous.
326 corresponding.
See, that is grievous. That is grievous. So let us see with the investigation. What
Yes,
is
your
the-
lordship. If your lordship investigation, if MLC come and if it revealed that it's a simple injury, then it's good
Yeah.
for them only, your lordship.
Good for you only.
Because my
Okay.
only submission is since they have settled the matter.
No, no, no.
Even-
Everything cannot be settled.
No,
Everything cannot be. But then if it is a grievous, it will be a little difficult. Let us see. Still then, we'll allow you, but then let us see the record. Okay, it will be good for you. So because on record. Okay.
Lordship, this matter was actually first
Mr.
listed for 19 only. However, last occasion on 8, it was referred to mediation. And this honorable court was of the view that since the parties have already settled the matter, therefore.
No, no, because it was listed for referring, but then since if it is since it was found to be a joint petition, no need to refer between the party
Exactly.
because party don't have to settle there.
Exactly, that was
Party already settled.
yes, exactly.
So, but then it is with the state, which we state
Yes,
cannot. So
and-
that is why.
And
So
my,
let us see the.
my lord, one
record.
more aspect was there, which was always from us, we failed to apprise this court, your lordship. The SOP is there for referring the matter for the mediation.
Yeah.
Only the compoundable offense can be referred, my lord. If suppose they are challenging on merit and it's a compoundable offense, then court can send it. But if it is non-compoundable, then your lordship, I doubt your lordship, I'm afraid that cannot be referred for the mediation because the mediation act
Probably
doesn't allow you.
on the basis of the.
Just highlighting because this was listed by the registry for in the mediation column. So
Register might not know
Yes.
the
Yes,
person who placed
yeah.
before,
therefore,
but then it should be the advocate who should point out
Yes, your lord.
whether this can be referred or not.
no,
So
therefore,
in the letter it says because they are now probably for this, I think scheme
Yes, your
of
lordship.
the referring
Yes, your lordship.
before the mediation, probably it will continue for some days.
Yes,
because
your
this
lordship.
Process is going on.
Yes, your lordship.
So if it is a non-compatible, just apprise the court.
Yes,
So the
your
court
lordship.
doesn't say anything.
therefore, I'm just highlighting the fact because it was wrongly listed in the mediation.
Yes,
So
yes.
this honorable court had directed not to refer it.
Yes,
to the-
yes.
So
Okay, now we'll call for the record.
and it was already fixed on 19.
Scan copy already called for.
Yes, we have not received the scan copy, my lord.
Okay.
That's the problem.
Initially, matter was directed to list on 19. Therefore,
My lord, I am not objecting on quashing of this matter, but to properly appreciate the fact, my lord,
Right, right.
on hazy fact, how this court can appreciate their, your lordship, petition, your lordship.
So this matter initially has been. Directed, just a minute. Why it was listed on 14? Sorry, 8? 8. Oh no, this is
it
initial
was
order.
wrongly actually listed in mediation column. Therefore, the honorable court has directed to list again today. However, initially on 5th,
It should have been, of course, directed for listing it on 19 only.
exactly.
But 19 probably did not.
Your lordship, let it be on 19, your lordship. We'll produce the case there on 19.
For the petition. Brought to the notice of this court that the matter has already been fixed on for 19/8/2025. Wherein, okay. List this matter on 19/8/2025 according. On which date? Not this stuff. On which date? The scanned copy of the case diary shall be produced.
Yes, your
Okay.
lordship. Deeply obliged.
Matter number 16 to 18.
My lord, this is a very long pending case.
Yeah.
So, and a very small issue is there, a law issue of law is there, my lord, regarding 468, your lordship. Now, the corresponding section is 514, my lord. The limitation for taking bar, is your lordship is aware,
Invitation for?
for taking your lordship cognizance by the magistrate.
Okay.
The limitation for institution prosecution, initiation of prosecution, 468.
468.
Yes, my lord. The corresponding provision is in the BNSS is now 514, my lord.
Okay.
So, a very small issue now, your lordship. Initially, your lordship, they approached the Lane JMFC. It was initially pending before charge sheet was filed, and it was cognizance was taken, wherein they have raised this issue that this court, the Lane JMFC judicial magistrate, has barred from taking cognizance because the limitation period was over. And but however, the Lane JMFC was not inclined to interfere and found that the interpretation regarding the provision was not in accordance to the law or according to JMFC. And subsequently, the impugn order was again challenged before the Lane Revisional Court, my lord. That is before the Session Court. And now there also the order was impugned. And now they are before this honorable court under 482, your lords.
No, what happened there in the session court?
Session Court, you upheld the finding of the Lane JMFC, my lord.
No interference.
Yes, no interference. Now here only the limited issue is, your lordship. For the purpose of computing the limitation, your lordship, which date will be the purpose for computation? So now, your lordship, there are so many judgments prior to the this Sarah Matthew case, your lordship. A Japanese Sao was there, Bharat Kale was there, and ultimately on Sarah Matthew, this matter was taken into consideration by the Constitutional Bench of the Supreme Court. When it was held that, your lordship, so far as commencement of death is concerned, that is not disputed. Either it will be from the date of commission of the offense or the death when it comes to the knowledge of the police or the victim, complainant. And till 468 is regarding till which date it will be computed. So now, according to the prosecution, for us, your lordship, there are two type of cases. One is FIR case for cognizable offense, and one is complaint case, which can be directly filed before the magistrate. So far as the complaint case is concerned, in Sarah Matthew case, the complaint case was basically, your lordship, dealt by the Honorable Supreme Court, wherein, your lordship, it has been held that from the date of filing of the complaint or institution of prosecution, till that, your lordship, the date will be computed, not when the cognizance is taken by the magistrate. So now, in this case, your lordship, we are not on the complaint case. Complaint case is very clear. From the day commission of the offense till filing of the complaint before the concerned magistrate or the concerned court. Now, here in this case is regarding from the day of commission of the offense till, according to us, till filing of the FIR, written complaint, not the filing of the charge sheet or not the cognizance taken by the magistrate. This is the issue here, your lordship. Only that much till when it should be computed, your lordship.
I haven't. When the occurrence took place, incident occurred.
Well, your lordship, date of...
Let us see the FIR first.
Yes, sir. Your lordship, will find the FIR in page 10 and 11. Item number 16.
2011.
Yes, Lord. May I read the FIR?
Yes.
To the officer in charge, police station Itanagar, FIR. Sir, it is to inform you that on 22 September 2011 at around 5:30, while I along with my wife, Mrs. So-and-so, coming back from Holongi and had stopped at the bridge point, suddenly a group of Chimpu boys numbering 6 person in 3 motorcycles, led by youth President Gyamar Changia, was stopped us and started attacking on us without any reason and forcefully snatched away my car key along with mobile phone, ATM, money, purse containing 15,000 and after keeping me at Dow short point, they dropped me at PHQ ATM and asked my wife to withdraw money from ATM. I somehow managed to escape to the guard of PHQ gate. The youth also assaulted my wife and also took my Centro car bearing number so-and-so and damaged some part of it. Therefore, I solicited you to kindly arrest this culprit and take necessary action.
Informant is
Yes.
no longer
He's missing, your lordship.
missing.
Yes, that's why This was one of the reason for long
Okay, just a
pendency.
minute. And thereafter what happened? The charge is filed on?
Lordship, charge sheet was filed after 3 long years on 9/10/2014.
After 3 years.
Yes.
Where do we find?
Lordship, charge sheet is at
Let us
Annexer
know the
2.
fact first, right?
Yes, page 12.
Page
12.
12.
Yes, the Annexer 2.
Forwarding of charge sheet. Okay, this was on
That is filed on 9/10/14.
9/10/14. So that means after 3 years.
Yes, 3 years.
Okay. So it was registered under which section?
Lordship, here it is registered under
41.
341, 384, 323. The,
So maximum punishment, which is the highest punishment here? 325.
Extortion.
yes, 3 years
384.
maximum.
3 years.
3 years.
3 years.
Yes,
Yes.
your lord.
That is minimum or the maximum?
Maximum.
Maximum 3 years, your lord.
Okay.
Maximum 3 years.
384.
Charge is also filed under the same section? Same?
Yes.
Yes, your lord. For 341, 323, 384, and 34.
We change.
Yes.
Okay. So
So, Lordship,
now it has reached to court when?
My lord, may kindly note the date. I will give the date, my exact date, your lordship.
Mhm.
That will be more convenient for your lordship. Your lordship. Your lordship, date of commission of offense,
Yes, 22/9.
22/9/2011. And date of lodging of FIR, same date, 22/9/2011. And charge sheet was filed on, my lord.
Hmm.
9/10/2014. And
Hmm.
the matter was endorsed by the CGM to the JMFC on 4/8/2016. 4/8/2016. And the cognizance was taken. Yes.
4/2.
Your
2016.
4/8/2016, my lord. 8 August 08.
Okay.
And my lord, the cognizance was taken
Just a
on
minute. Where do we find this endorsement? Four, eight.
Correct.
this is put yes. Annexer 3, page 20.
20.
On item, first item.
First item, Yumlam Tani case, my lord. In Annexer 3, page 20, my lord. That is the,
Just a minute.
Yes.
One.
here the important is date only, my lord.
Yes, sir. That is right.
And your lordship, cognizance was,
Okay, then thereafter.
and your lordship, the cognizance summon was issued on 9/3/2016. Your lordship will find in page 21, Annexer 4. 9/3,
Hmm.
March 2016.
The page.
Page, your lordship, 21.
Yes.
4/3.
My lord, the endorse was on 4/3, my lord. It's not 8/3. 4/3/2016.
Page.
Your lordship, page 20, the endorsement, my lord, the endorsement part, endorsement by the CGM to JMFC. It was not, there is 4/3, not 8.
Okay. No, there's endorsement is of course 4,
3,
not 8.
yes, 4/3. In
Yes.
2016,
Yes, sir.
and someone was issued on 9/3/2016.
Okay.
Now everything is depend on this date now, your lordship.
Now let us see the provision.
Yes, your lord. CRPC will apply because it's pending, my lord. CRPC would apply, my lord. 468, my lord.
468.
CRPC, not
Yeah.
DNS. Yes, yes.
Merit 468.
Hmm. Just a minute. Yes.
Part to take cognizance after lapse of period of limitation.
Hmm.
1. Except otherwise provided elsewhere in this code, no court shall take cognizance of an offense category specified in subsection 2 after the expiry of period of limitation.
Yeah.
The period of limitation shall be 6 months if the offense is punishable with fine only. B. 1 year if the offense is punishable with imprisonment for a term not exceeding 1 year. And 3 years if the offense is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years.
So C applies.
Yes.
See would apply in this case.
Hmm. So
So
this was after 3 years.
yeah.
Now, yes, your lordship. Now I will come to the, your lordship. Let my brother first.
Okay.
Yes, yes, your lord.
So, 3 for this purpose of this section, the period of limitation in relation to the offense may be tried together shall be determined with reference to the offense which is punishable with more severe punishment or the S case may be with maybe the most severe punishment. So, by subsection 3, that this C will apply. Now, lordship, my case is that lordship, when we see the section, we have to see the chapter as a whole. Here, chapter 36 have to be read as a whole. All the sections given in that in this chapter. Therefore, Lordship, what happened was that on 22/9/2011, date of incident. Now, period of limitation starts from there. But where it ends, Lordship, by interpretation, Lord, with the date when the charge sheet is filed. Because if we take as a date in which FIR is there, because when charge sheet is filed, at that time, the magistrate applies his judicial mind. Now, it cannot be said that when period of limitation ends on the same very day when incident is reported to the police officer. That will be my interpretation, Lordship. Because if we further see some sections furthermore, Lordship. Now, commencement of a period of limitation, it is clear, we are not disputing on that, Lordship. Now, 470 also have to be read.
It's not clear from here. That cognizance from the charge sheet only.
No, no, my lord.
Not
Law is settled, my lord. In fact, your lordship, in the present case, C ought to have come if there was a delay. There is not even a single day of delay, my lord. I will come with the judgment, your lord. Not the charge sheet will not come, my lord. Cognizance part is already decided by the Supreme Court. That cognizance, day of cognizance will be not computed for the purpose.
The end line is 9/3/2016.
The 9/3/2016 is the cognizance.
Cognizance.
Yes. Your lordship,
So,
this part
only-
that
only
cannot be taken into consideration.
Which date to be?
Lordship,
Okay.
for my case is Lordship in a safeguard.
Yes.
My case is that I'm not going into when this code 9/3 or 4/3 when it was endorsed. I'm not on that. Lordship, when charge sheet is filed before a magistrate, I'm taking that to be the limitation period because at the time of filing of the FIR, a magistrate does not give his judicial mind. Now, initiation of criminal proceeding means what? That when a magistrate applies his judicial mind, at the time of FIR, receiving FIR, a magistrate does not apply his judicial mind on that facts of the case. Therefore, when charge sheet is filed, that at that time magistrate applies his judicial mind that whether charge has been filed or properly filed or not, whether this limitation is there or not. Therefore, there is a section 470 also that exclusion of time in certain cases. And further, it says that exclusion of a date on which court is closed. Merit 471 also, where the period of the limitation expires on a day when the court is closed. The court may take cognizance on the day on which the court reopens. And it is continuing offense also. And furthermore, merit 473 also, extension of period of limitation in certain cases also. Notwithstanding anything contained in foregoing provisions of this chapter, the any court may take cognizance of an offense after expiry of period of limitation if it is satisfied on the facts and circumstances of the case that delay has been properly explained.
Are you for the accused or for the,
Accused, Lordship.
you are for the accused?
Yes. Therefore, is that when charges is filed before a magistrate, the police have to exercise, or the public prosecutor and the magistrate have to exercise that, yes, why there was a delay, they have to explain. But in Lordship, if suppose we take, for example, today offense is there is a delay in FIR, lodging FIR. Now that delay don't have to be explained. Why did it has to be explained, but not under provisions of 473 Lordship. 473 is that it can be, it is a condonation application. It's here in the interest of the justice, the delay has to be properly explained, which was not done in this case. This matter before, when the magistrate have accepted the charge sheet, at that time, the public prosecutor or the SP should explain that there was there was 70 days delay in filing this charge sheet. This has to be exercised. That's why whenever we read any provisions of law, this chapter has to be read as a whole, not only that section. So this 468 has to be interpreted in a that way that, yes, date of offense is so and so. FIR cannot be said to be initiation of criminal proceeding. Initiation of criminal proceeding has to be interpreted in a way that where a magistrate applies his judicial mind. Otherwise, Lordship, if we do not read the whole, this just exclusion of time in certain cases. So, Lordship, here what says that there are certain time which has to be excluded from this period of limitation.
According to you, it should be counted from.
It should start from the date of offense till filing of the charge sheet. According to me.
No. Why according to you? It should be according to law only.
Yes, according to my Lordship.
Cognizance, you see,
Sorry.
the statement of law. They'll take cognizance.
Yes.
We're talking about the cognizance.
Lordship, that has been clear. Cognizance, Lordship, that has to be. If from the period, Lordship, if from it should start from the date of offense, then at the time of filing of charge sheet, because at the time of filing of the charge sheet, there is 17 days delay. At the time of filing of charge sheet, what happens that magistrate applies his judicial mind, and it takes that whether I have to take charge sheet have to be given for re-investigation, or if there we have to wait for supplementary or like that. Not only after that it has been endorsed. So even if we take charge sheet as a, if we take date of cognizance, then it's definitely delay. But Lordship, my humble understanding is that it should be the date of charge sheet.
From
Date of offense.
From date of offense
To filing of the charge sheet.
One of the issue.
Yes. Because at the time of filing of charge sheet, only then we can say that criminal initiation has proceeded. Now, if we take from date of offense till filing of the FIR, that for me that when FIR is given in the court.
So according to you, from the date of offense
Yes.
to filing of charges,
Charge sheet.
how many day of delay?
17 days.
So this is according to you.
468, 3 years.
So,
3 years,
according to him, my
3
lord,
years,
from the
17 years.
date of commission of the offense
Hmm.
till filing of the charge sheet would be considered as a limitation period, according to him.
Yes.
And in
And
this
then-
case, 3 years has been expired.
Yes.
This is his case.
17 days exceeded.
Yes, exceeded.
Yes.
And there was no proper explanation under
But that-
473 also, that this provision was not exercised. It could have, if it was exercised by the investigating officer or the SP, Superintendent of Police, then this defect could have been cured. Or by the public prosecutor at the time of that issuing summons. That it could have been cured also. That's why it was not exercised. 473. Because if Lordship, if we calculate the time from date of offense to force, if we calculate the time from date of offense to till filing the FIR, then 473 becomes the redundant, Lordship. It will serve no purpose for this section. This section is for that only, Lordship.
So according to you, this defect
Yes,
could have been cured by
section 473 by the public prosecutor or the by the court also and by the investigating officer also.
okay.
Yes.
So that's your
Yes,
submission.
that's my submission.
Okay.
And Lordship, this whole chapter have to be read as a whole. Not
Okay. Yes.
Yes, my lord, now, your lordship, I will take reference of the BNSS also in this case.
Hmm.
And then I will come to the judgment of the Honorable Supreme Court and the various High Court, my lord. Here, your lordship, according to the settled law, for the purpose of limitation in GR case, it will be, my lord, date of occurrence till filing of the written information to the police. Not the charge sheet, not even the cognizance. I will come with the judgment to that also. Not the charge sheet, my lord. Because, your lordship, why this observation? I will come with all this observation from the Supreme
From
Court.
the date, just a minute. From the date of
Commission of the offense till filing of the FIR, my lord. Written complaint. Charge sheet, cognizance, that will not be included for that purpose.
till the date of
Filing of
Filing
the
of-
written complaint, that is FIR. Or filing of the complaint directly before the magistrate. I am only confined to the GR case, my lord. Complaint case I am not arguing because complaint case is clearly decided by the Supreme Court in Sarah Matthew case. I will referring the judgment also, my lord.
Hmm.
So now, my lord, the sum,
so that means according to you there-
no delay, nothing, no delay, my lord, no delay at all. There was only a misunderstanding of law, my lord, misinterpretation of law, misconception of law. Now, your lordship, I will refer to the BNSS. Why I am coming to BNS, your lordship? Because there are so many, this 468 has came for been many occasions before the consideration of the Supreme Court, your lordship.
Hmm.
And it has been settled. Basing on that, in corresponding section, explanation has been given by the legislature, my lord. Now, your lordship may come to the corresponding section of 468 is 514, my lord. Everything is identical except for the explanation, my lord. Although in this case, your lordship, it is not applicable, but that inference can be drawn that basing on the settled law settled by the judiciary, your lordship, this explanation has been given by the legislature. Now, your lordship, I'm just referring, I will come to the judgment later on. Your lordship, BNSS 514, corresponding provision of this 468, my lord. BNSS 514, my lord. May I read, your lordship?
514.
514, my lord. The corresponding section of 468 of CRPC. Yes. Now, your lordship, 515 I'm starting. Why? Because we have to know when it will commence, when clock will tick, your lordship. First commencement, this same corresponding to 469, your lordship.
515.
515, yes, your lordship. Then I will come to 514. The period of limitation in relation to an offense shall commence, when it will commence, A, on the date of the offense, or where the commission of the offense was not known to the person aggrieved by the offense or to any police officer, the first day on which such offense come to the knowledge of such person or to any police officer, whichever is earlier. See, where it is not known by whom the offense was committed, the first day on which the identity of the offender is known to the person aggrieved by the offense or to the police officer making investigation into the offense, whichever is earlier. In computation of the said period, the day from which such period is to be computed shall be excluded. Now, your lordship, now we know from where clock will start, my lord. The clock will tick. Now, till when? The date is 514, your lordship. Now, 514, my lord, may kindly come.
Just a minute. Yeah.
Yes.
The date of offense.
Yes, your lordship. Now, in this case, A will come, date of offense, my lord, 22nd.
So section 14, 514.
Yeah, now, your lordship, 514, that is corresponding to 468. Now, your lordship,
Yeah.
we understood that what law say, statute said, it will commence when it will initiate from the date of commission of the offense. Now, 500 will make it clear till when, my lord. So now 500 is the corresponding of 468. My lord, everything is similar. I will come directly to explanation, my lord. Explanation, my lord. Your lordship, find the explanation. For the purpose of computing the period of limitation, the relevant date shall be the date of filing of complaint. That is, my lord, complaint case. Under section 223, this is complaint case. This is corresponding to section 200, 223, my lord. In complaint case. Then it will be day of filing of the complaint. Now we are not on the complaint, or, my lord, now this is for the GR case. The date of recording of information under 173. 173 is, my lord, corresponding section of 154 FIR, my lord. There is no any term of FIR. However, your lordship, 154 is term as first information report for the commission of the offense, my lord. This is corresponding to 154, my lord, 173 CR BNSS. So here, everything has been clarified in the BNSS, my lord. (173) is, my lord, 154 corresponding FIR, my lord.
170.
3 is corresponding to section 154 of CRPC, my lord. FIR, that says FIR.
One,
my lord, information in cognizable cases.
154.
173, my lord, may directly in BNSS, your lordship will find.
154.
Yes, corresponding section. The meaning thereby, it is the date of information.
No, 154.
Yes,
Yes.
corresponding section 173.
Person to whom order is addressed to be to obey or so called.
No, my lord might have opened your lordship. You, my lord, in BNSS 173. In BNSS 173, my lord.
Oh, BNSS 173.
Yes, because I'm reading the provision of BNSS, my lord.
Okay.
So we have to see 173 refer corresponding to which provision of the CRPC, my lord. Or what 173 says, my lord.
173.
Yes.
Information in cognizable case.
Yes, this is FIR, my lord. 154, corresponding to 154 of CRPC, my lord. Now, your lordship, BNS make it everything
173 is the corresponding.
to 154 of CRPC. It's written in the end of the provision, your lordship. 154.
Just a minute.
Yes.
Yes, it's fine.
BNSS is very clear. Now, BNSS says it will be date of for the purpose of computation of limitation. It will be the for the complaint it shall be 223. That is section corresponding to 200 when the complaint is filed before the magistrate. And for GR case, for cognizable offense, when information FIR is filed, then on the day when FIR is information is given to the police, BNSS make it clear.
Okay, which,
My lord, my lord, this 514 explanation, your lordship, it says for the purpose of
514?
yes, your lordship, or BNSS, my lord. The corresponding to 468, my lord.
Yes.
My lord have seen the 173 have my lord already gone into. Your lordship directly go to the explanation, my lord.
173?
173 is the corresponding of the 154, that is FIR, my lord.
Yes.
Now, your lordship, in 514, that explanation has been
For the purpose of computing.
yes, your lordship. For the purpose of computing the period of limitation, the relevant date shall be the date of filing complaint under 223. This is for complaint case, my lord. Or the date of recording of information under section 173 is directly indicate FIR, my lord. The date of information is the FIR.
For the purpose of computing the period of limitation,
Yes, your lordship.
the relevant date shall be the date of filing complaint.
Yes. Under 223.
And section 223,
223 is, my lord, 200 corresponding to CRPC, my lord.
or the date of recording the information under section 173.
That is 154 of the CRPC. Meaning thereby it's the information when information received by the police. If your lordship allow, then your lordship let us furthermore clarify it with the judgment of the Supreme Court, my lord, and one High Court, your lordship. Because your lordship, since BNS is not applicable in this case, since this case was pending when CRPC was in force, and then prior to that also this case was filed. So now, your lordship, I have to rely on the judgment of the Honorable FX Court to substantiate my argument, my lord. Before the
Okay,
judgment,
just let us clarify. According to you, it should, the limitation start running from the date of filing of FIR.
yes, my lord.
And,
In complaint case,
no, the
Oh.
date of occurrence
till
till the filing of FIR.
yes, your lordship. Because 500, your lordship, I prefer to the
No,
500.
Anyway.
Commencement, your lordship, is very clear from the date of offense, my lord has gone through. And second part, till when, date 514 clearly says, 468 says, explanation clearly says, from when the information is recorded. And information recording is the FIR, my lord, not the charge sheet. Charge sheet cannot be an information recording. So, my lord, before the Sarah Matthew case, I have one more judgment I have referred to. After Sarah Matthew, because you know, Sarah Matthew was reiterated on basing on the Sarah Matthew, the second judgment comes. In Sarah Matthew case, it was reported in 2014 to SCC 62. My lord.
This is para 33.
No, my lord, your lordship, the
Sarah Matthew.
I will read from 24.
Sarah
Onward,
Matthew.
yes, your lord.
24.
24. Your lordship, the object behind your lordship inserting 468, we have to understand, my lord. Here, the Sarah Matthew in this case, the objective, the purpose, why magistrate cognizance will not be considered, taken to consider. All this aspect has been dealt here in the Sarah Matthew case.
Para 24.
24, my lord, I will read, my lord. Para 24. Read in the background of Law Commission's report and the report of JPC, it is clear that the object of Chapter 36 inserted in the Criminal Procedure Code was to quicken the prosecution of complaints and to rid the criminal justice system of inconsequential cases, displaying extreme lethargy, inertia, or indolence. The effort was to make the criminal system more orderly, efficient, and just by providing period of limitation for certain offences. In Swan Singh, this court stated that the object of Criminal Procedure Code is putting a bar of limitation as follows. The object of the Criminal Procedure Code in putting a bar of limitation on prosecution was clearly to prevent the parties from filing case after a long time, as a result of which material evidence may disappear, and also to prevent abuse of process of the court by filing vexatious and belated prosecution long after the date of offense. The object which the statutes seek to subserve is clearly in consonance with the concept of fairness of trial as enshrined in Article 21 of the Constitution of the India. It is therefore of the utmost importance that any prosecution whereby the state or the private complainant must abide by the letter of law or take the risks of prosecution failing on the ground of limitation. Here also, your lordship, the object is very clear. So that the case should not be reported belatedly or complaints should not be filed belatedly. Now, para 25. It is equally clear, however, that the lawmakers did not want cause of justice to suffer in genuine cases. The Law Commission recommended that provisions for exclusion of time, and those provisions were made part of Chapter 36. We therefore find in Chapter 36 provision for exclusion of time in certain cases, Section 470 for exclusion of death in which the court is closed, 471 for continuing offense, 472, and for extension of period of limitation in certain cases, Section 473. Section 473 is crucial. It empowered the court to take cognizance of an offense after the expiry of period of limitation. If it is satisfied on the fact and in the circumstances of the case that the delay has been properly explained or that it is necessary to do so in interest of justice. Therefore, Chapter 36 is not loaded with the complaint. It is true that accused has a right to have a speedy trial, and this right is facet of Article 21 of the Constitution. Chapter 36 CRPC does not undermine this right of the accused. While it encourages diligence by providing for limitation, it does not want all prosecution to be thrown overboard on the ground of delay. It strikes a balance between the interest of the complainant and the interest of the accused. It must be mentioned here that where the legislature wanted to treat certain offense differently, it provided for limitation in section itself. For instance, Section 198(6), subsection 6, and 199, subsection 5 CRPC. However, it chose to make general provision for limitation for certain type of offenses for the first time and incorporate them in Chapter 36 of CRPC. Now, your lordship may directly come to para 33. May I read, my lord?
Yes.
After referring to the provision of CRPC quoted by us herein above, in Videocon International Limited, this court explained what is meant by term taking cognizance.
Para 33 of the same.
33, my lord, yes. Same judgment.
Sorry.
Para 33, my lord.
Yes. Yes.
Please note that. After referring to the provision of CRPC quoted by us herein above, in Videocon International Limited, this court explained what is meant by term taking cognizance. The relevant observation of this court could be quoted. The expression cognizance has not been defined in the code, but the word cognizance is of the indefinite importance. It has no esoteric or mystic significance in criminal law. It merely means we could become aware of, and when used with reference to a court or a judge, it cannot to take notice of judicially. It indicates the point when a court or a magistrate take judicial notice of an offense with a view to initiating proceeding in respect of such offense said to have been committed by someone. Taking cognizance does not involve any formal action of any kind. It occurs as soon as magistrate apply his mind to the suspected commission of the offense. Cognizance is taken prior to commencement of criminal proceeding. Taking of cognizance is thus a sine qua non for condition precedent for holding a valid trial. Cognizance is taken of an offense and not of an offender. Whether or not a magistrate has taken cognizance of an offense depend on the facts and circumstances of each case, and no rule of universal application can be laid down as to when a magistrate can be said to have taken cognizance. Now you will see para 34. Thus, a magistrate takes cognizance when he apply his mind, takes judicial note of an offense with a view to initiating proceeding in respect of offense which is said to have been committed. This is the special connotation acquired by term cognizance, and it has to be given the same meaning wherever it appears in chapter 36. It bears repetition to state that taking cognizance is entirely an act of magistrate. Taking cognizance may be delayed because of several reasons. It may be delayed because of systematic reason. It may be delayed because of the magistrate personal reason. Now, Your Lordship, here the Honorable Apex Court had given stress that the magistrate part cannot be taken into consideration because there are many factors because of which there may be delay in further proceeding with the matter. And the one's complainant and victim should not be suffer because of the delay caused by the judicial proceeding. Now, Your Lordship, as my brother has indicated, the chapter has to be considered as a whole. Now, Your Lordship, on heading also, in para 47, the Supreme Court has interpreted, Your Lordship. Para 47, my Lord. Here, Your Lordship, it was held that, Your Lordship, heading or the subheading prefixed to this chapter or the section cannot be referred for the purpose of construing the provision, my Lord, when the word used in the provision are clear and unambiguous, nor can be...
47.
Yes, my Lord. It starts with so far as the heading, my Lord.
Yes.
So far as the heading of the chapter is concerned, it is well settled that heading or title prefixed to sections or group of sections have a limited role to play in construction of statute. They may be taken as very broad and general indicator or the nature of subject matter deal with thereunder, but they do not control the meaning of the section if the meaning is otherwise ascertainable by reading the section in proper perspective along with other provision. In Frederick India Limited versus Union of India, this court has observed as under. It is well settled that the heading prefix to section or entries cannot control the plain word of the provisions. They cannot also be referred for the purpose of construing the provision when the word used in the provisions are clear and unambiguous, nor can they be used for cutting down the plain meaning of the words in the provision. Only in the case of ambiguity or doubt, the heading or subheading may be referred to as an aid in construing the provision, but even in such case, it could not be used for cutting down the wide application of the clear word used in the provision. So now, my Lord, the chapter cannot be simply because of the heading, the chapter cannot be interpreted, my Lord. The provision has to look into by its own, Your Lordship, own understanding, my Lord. Own construction should be given when the words are clear and plain, my Lord. When there is an ambiguity, then chapter will be taken as a aid, my Lord. Now, Your Lordship, may kindly come to para 47, my Lord. The conclusion, not 47, my Lord, 51, my Lord. My Lord, last. In view of the above, we hold that for the purpose of computing the period of limitation under section 468 CRPC, the relevant date is the date of filing of complaint or the date of institution of prosecution, and not the date on which the magistrate take cognizance. We further hold that Bharat Kale, which is followed in Japanese Sahu, lays down the correct law. Krishna Pillai will have to be restricted in its own fact, and it is not the authority for deciding the question as to what is the relevant date for the purpose of computing the period of limitation under section 468 CRPC. Now, Your Lordship, my brother has pointed one
Institution of prosecution.
yes, Your Lordship. He has pointed out. No, my lord, that has also been clarified. I will come to that judgment again, your lordship. Because, your lordship, even I am aware of this, your lordship, interpretation that criminal prosecution instituted is said to be instituted when magistrate take cognizance. But for the purpose of this section, my lord, the Supreme Court has not indicated to that extent. That is why, my lord, I have this heading part, your lordship.
That and note the date on which the magistrate take cognizance.
Yes, cognizance part gone. That will not come. That part is gone, my lord. And the second part is the filing of the complaint. Now my brother will come with the proposition that section 2 of the definition has to be looked into, because there the complaint has been defined. And now the second part, or is given. This or is, my lord, not given for the FIR case, my lord. This is a general concept. And here in this case, interestingly, your lordship, the Supreme Court was dealing with the complaint case, not with the GR case. Now let us come to the, my lord, GR case. And then this will be, the picture will be more clear, my lord. The second judgment, my lord, I have given to your lordship. That is, my lord, the Amrit Lal and versus Santilal Soni.
Yes.
My lord, here this is reported in 2022 SCC Online SC 266.
Yes.
Now, your lordship, here in this case, your lordship, in this case, your lordship, the dates are very important, my lord. The date has to be appreciated. Then we'll understand the actual appreciation of law. My lord, the fact is in para 4, my lord.
Yes.
Para 4, yes. Shown of unnecessary details, the relevant background aspect of the matter that on, my lord, 10/7/2012, the present applicant filed a written complaint to the Superintendent of Police, Kutch Road, while claiming that he had entrusted 33.139 gram of silver to the respondent. And on 4/10/2009, on the demand being made, the respondent refused to return the same. On the complaint so filed by the appellant, the FIR bearing number so and so came to be registered, and after investigation, the police filed charge sheet dated so and so for the offense aforesaid against the accused person. Respondent number 1 and 2, thereupon judicial magistrate to cognizance on so and so. Now, your lordship may kindly note down the 3 date. First is FIR was recorded on 10/7/2012, my lord. FIR date. And date of cause of action was on 4/10/2009, my lord.
Yes. Yeah.
Yes.
So one of them. I'm saying that. The relevant document on 2012, the present the written complaint.
Yes, madam.
2012.
Yes, your lordship. On your lordship, that may be, your lordship, that is very vital for understanding this.
Yes, 2012.
Yes, 2012.
Claiming that he had impacted control. That's not issue, that's exchange. No. Silver to the respondent of, okay. So he will be back to 2019. Okay.
Your lordship, here in this case, on 10/7/2012, FIR was filed, my lord. And your lordship, the police filed charge sheet on 13/11/2012.
Yeah.
And cognizance was taken on 4/12/2012.
Yeah.
The cause of action was on 4/10/2009 when he
Yeah.
claimed.
Yeah.
So now, your lordship, let us see which date has been taken by the Honorable Supreme Court for the purpose of limitation. Now that is directly.
Okay.
Yes. Now, para 10, my lord. Your lordship, in para 8, the judgment of Sarah Matthew was reiterated. That was again reappreciated by the Supreme Court in para 8 and 9.
Okay.
So that is not required to be again, your lordship, repeat.
Okay.
So now 10, your lordship, for better understanding.
10, okay.
Therefore, the intuitions and declaration of law by the constitutional bench do not admit any doubt that for the purpose of computing the period of limitation under section 468 CRPC, the relevant date is the date of filing of the complaint or the date of institution of prosecution, and not the date on which the magistrate take cognizance of the offense. The High Court has made a fundamental error in assuming that the date of taking cognizance, that is 4/12/2012, is decisive of the matter. Now that is clarified. Why? Ignoring the fact that the written complaint was indeed filed by the appellant on 10/7/2012, my lord. The FIR has to be taken into consideration well within the period of limitation of 3 years within reference to the date commission of offense. Date of commission till, my lord, filing of the FIR has been taken into consideration. Yes, it is very clear, man. And now, your lordship, and here also, your lordship, this honorable apex court has not ignored the Sarah Matthew case. Sarah Matthew case was reiterated in paras 8 and 9, my lord, by the constitution bench, and it was further held that it will be commission of the offense till filing of the FIR. Now, your lordship, one more judgment from the High Court.
Just a minute, just a minute.
Yes, your lord. Charge sheet was not at all taken into consideration, my lord. Only the date of commission of the offense, that was on 4/10/2009, and filing of the complaint, that is on 10/7/2012. Yes, your lordship. The filing of the FIR complaint. And this is a GR case, not a complaint case, my lord. Yes, your lordship. 2022 matter, man.
Okay.
And my lord, and one more, your lordship, the Rajasthan High Court judgment, my lord. For reference, it's up to your lordship. But is in consonance with the Honorable Supreme Court finding, my lord. The Rajasthan High Court judgment. This was of 2020, my lord.
Yes.
In Bina Bajaj versus State of Rajasthan, my lord.
Hmm.
Para 1.
Yes.
The petitioner by a criminal petition challenged the cognizance taken by the competent court on the ground that the cognizance has been taken on 11/12/2013, while the FIR was lodged on 26/4/2010. The cognizance is barred by limitation as provided under the provision of section 468. Here again, your lordship, the FIR was filed on 26/4/2010. Cognizance was taken on 11/12/2013. There is no any question of charge sheet here also, my lord. So now your lordship may directly come to para 6. In para 6, the Sarah Matthew judgment was reiterated by the Rajasthan High Court. Now, Your Lordship, the operating parts is para 7.
There are 6. There are
Para 6 is the Sara Matthew, Your Lordship. It's a constituent bench judgment. Now, after reiterating, Your Lordship, the Sara Matthew judgment, the Honorable High Court, Rajasthan High Court coordinate bench come to this conclusion, my lord. In view of the aforesaid, if the fact of the present case are examined, then it is clear that the criminal complaint filed by the complainant under section 406 and 498A IPC will have to be examined on facts of the question of limitation. The complaint has filed on 26/4/2010, and the allegation labeled in the complaint are in relationship with the incident which occurred in 2010 itself, my lord. Here again, my lord, the date of incident is in 2010 and FIR was filed on 26/4/2010. Thus, it cannot be said that the complaint filed by the complainant was beyond limitation. Hence, the provision of 468 CRPC shall not be attracted in present case, and the cognizance and the subsequent order of framing of charge would therefore not be said to be in any manner illegal and vitiated on the ground of limitation. Here again, Your Lordship, same now. So now, Your Lordship, so far as charge sheet is concerned, my lord, here also, Your Lordship, the date of FIR was 26/4/2010. 26/4/2010, and date of incident was 2010. The cognizance was taken.
In the present case.
Yes, Your Lordship. In the present case, Your Lordship, the Rajasthan High Court case. Here, Your Lordship, the date of incident was in the year of 2010. The FIR in the very paragraph 1, Your Lordship, it has reflected 26/4/2010, the FIR was lodged. And in last para 7, my lord, it was clarified that the complaint has been filed on 26/4/2010, and the allegation level in the complaint are in relation to the incident which occurred on 2010 itself. So it was commenced on 2010 itself, and it was reported in 26/4/2010 itself. It was not regarding the filing of the charge sheet or the cognizance taken by the magistrate. The same in consonance with the Honorable Apex Court judgment, my lord.
No, this talk about a cognizance or
Yes, Your Lordship. Either it will be a cognizance, Your Lordship, or the FIR, but this has been decided by the Supreme Court. Your Lordship, the question of charge sheet will not come at all. Why, my Lord? I'm saying submitting. Your charge sheet is dealt by section 173 of the CRPC, which does not, Your Lordship, does not impose any limitation, my Lord. 173, my Lord, the charge sheet. Your Lordship, actually, the charge sheet is the statutory it's mandatory by statute, my lord. Otherwise, Your Lordship, the investigation, act of investigation complete when the IO or the investigation officer form opinion to draw the report. And the statutory mandate is that he has to file that report to the concerned magistrate for purpose of taking cognizance and purpose of trial. So there are two stages, my lord. One is completion of the investigation and then filing of the charge sheet. And the act of investigation cannot be considered as, Your Lordship, considered as a by the filing of the charge sheet, my lord. So now, in Your Lordship, so far as the charge sheet is concerned, my lord, the charge sheet is governed by section 173 of the CRPC, my lord, which does not impose, Your Lordship, any limitation. It does not impose, Your Lordship, any limitation for filing of the charge sheet. No time is given, Your Lordship. Even if there is a delay, for that explanation has to be given by the investigation authority, that's it, but not for the purpose of 468, but 173 itself. Because 173, which deal with the charge sheet, which itself is considered a charge sheet.
173 GNSS.
CRPC, my lord.
CRPC.
And BNS would be, Your Lordship, the corresponding provision is
173.
Yes, your lordship. It deal with the charge sheet. Yes, my lord. Now, 170.
The 167, CRPT.
173 is the charge sheet in CRPC, my lord. And its corresponding is, my lord, 193, my lord. 193. My lord, we are in CRPC now. Your lordship, let us see, your lordship, whether 173 impose any restriction or limitation for filing of the charge sheet or not.
Okay, like, the IO can.
Yes,
Permission.
yes, here say
Correct.
every investigation under this chapter shall be completed without unnecessary delay. The first subclause, it clearly says every investigation under this chapter shall be completed without unnecessary delay. That much only. There should not be any delay, my lord. And your lordship, this clause subsection A, it says for these sections, your lordship, it says it shall be completed within 2 months. For the provision for the charge sheet, it itself provides some limitation, my lord. It cannot be read along with 468, my lord. 468 is independent section, my lord. It says the second part is 1A, the investigation in relation to offense under section so and so, these are gang rape and rape, my lord, shall be completed within 2 months from the date on which the information was recorded by the officer in charge of the police station. 2, as soon as it complete, the officer in charge of the police station shall forward the magistrate empowered to take cognizance of the offense on report, a report of the form prescribed by the state government stating so and so. These are the requirements which are to be accompanied with the charge sheet. And 2, the officer shall also communicate in the manner in which the government has taken action against the person to whom the information is so. This is to instruction to the officer concerned. Where superior officer of the police has been appointed under 158, the report shall in any case. Here also no limitation, my lord. Whenever it appears from the report forward under this section that the.
You are reading which one?
Your lordship, 173.
173.
Yes. Subsection 3, my lord. 1A impose limitation.
Where superior?
Paragraph 3, my lord. My lord, 173 subsection 1A. It imposes certain limitation.
1A.
Yes.
Are we in CRPC?
Yes, my lord, we are in CRPC.
173.
170 subsection 1A. Capital A, my lord.
Capital A.
Yes.
The investigation in.
Investigation in relation to an offense under section 376. This all offense related to sexual assault, my lord, shall be completed within 2 months.
Yes.
From the date on which the information was recorded by officer in charge of the police station.
Yes.
Here, your lordship, limitation is given for certain offense. But that too, my lord, in my humble understanding, if there is a delay, reasonable delay, it cannot be quashed, that FIR also, or the charge sheet, my lord. Because it says as long as possible, my lord, the 2 months, within 2 months, it has to be completed. And the 173, it itself is independent section for the charge sheet, my lord. Now, for certain offense, limitation has been given. Now, subsection 2 provides, your lordship, that charge sheet should be accompanied by what materials, my lord? A, B, C, D, E, F, G, H, my lord. These are the material to be accompanied with the charge sheet. And subclause 2 of subsection 2, it says, the officer shall also communicate in such a manner as prescribed by the state government, the action taken by him to the person, if any, by whom the information relating to the commission of the offense was first given, my lord. Now, to the informant also, my lord, which is not, no doubt, which is not strictly followed as on that by the police. But subclause 2, my lord, says, the what action the police has taken, that has to be informed to the informant, my lord. Now, 3, where a superior officer of police has been appointed under 158, the report shall in any case in which the state government by general or special order or so direct be submitted through that officer, and he may, pending the orders of magistrate, direct the officer in charge of the police station to make further investigation. Whenever it appears from the report forward under this section that accused has been released on his bond, the magistrate shall make such order for discharge of such bond or otherwise if he think fit. 5. When such report is in the respect of case of which section 170 applies, the police officer shall forward the magistrate along with the report A, all document relevant extract on which extract thereof on which the prosecution proposed to rely other than already sent to magistrate during investigation. B, statement recorded under 161 of all the person whom the prosecution proposed to examine as witness. 6. If the police officer is of the opinion that any part of such statement is not relevant to the subject matter of the proceeding or that is disclosure to the accused is not essential in the interest of justice and is inexpedient in the interest, public interest, he shall indicate that part of the statement and the append and note requesting the magistrate to exclude the part from the copies to be granted to the accused and stating his reason for making such request. Where the police officer investigating the case find it convenient so to do, he may furnish to the accused copies all or any of the document referred to the in subsection 5. 8. Nothing in this section shall be deemed to be preclude further investigation in respect of the offense after a report under subsection 2 has been forwarded to the magistrate and there whereupon an investigation the officer in charge of the police station obtain further evidence oral or document he shall forward the magistrate for further report regarding such evidence in form of prescribed and the provision of subsection 2 to 6 shall as far as may be apply in relation to such report or report as they apply in the to the report forwarded under subsection 2. Now, Your Lordship, 173 does not impose any restriction to the police. No doubt, subsection 1 says every investigation under this chapter shall be complete without unnecessary delay. So now this is the independent section. It cannot be read along with 468. Now, Your Lordship, one more provision Your Lordship, I have to apprise Your Lordship, where certain limitation is imposed by the legislature. And that cannot be read along with 468 because these sections are independent, my Lord.
Yes.
That section is, my Lord.
Mr. Rathir,
Yes.
what I am thinking now.
Yes, Your Lord.
because, Today is the last day,
Yes.
and I don't want to carry.
Okay, Your Lordship.
So, but then we'll keep it part hard.
Yes, Your Lordship.
I would like to take up this matter.
Okay.
I have part hard, but then the conclusion part, I'm also yet to confirm.
Yes,
And
Your
in the meantime, I'll also see the provision if there is any. So, what we'll do is I'll keep it as a part hard. Can I, or you don't want to keep it as a part hard? No, okay.
My Lord, keep it part hard, my Lord.
Okay, that will be better.
Yes, Your Lordship.
I also would like to see.
Yes, Your Lordship.
No?
Yes.
So what we'll do is we'll keep it as a part hard, and as and when I come, so we'll take.
Obviously, yes, of course, Your Lordship. No
Okay.
issue.
So next time probably you may also have to come a little more preparation in this regard because he has shown this you have seen the
Amritlal
Hmm.
Rajasthan.
clarification.
Yes,
Raj-
Lordship. Yes,
Rajasthan one.
Rajasthan
So
one.
if there is any more clarification, the latest, if this is of Rajasthan is of 2020.
And
2020.
yes, and
If
Supreme Court
there
is
any
2022.
So just see if it has been overruled.
No, my Lord, the Supreme Court judgment is of 2022. Amritlal, my Lord.
Amrita.
Yes, there also, Your Lordship, date of FIR and commission of offense has been taken.
Mhm.
So, if the Supreme Court 2002 judgment is stand, my Lord,
Mhm.
then Amritlal will stand, or that the Rajasthan High Court will stand because they both are in the same footing, my Lord.
Because we also thought that it's there of taking cognizance.
Yes, Your Lordship.
So
Initially, Your Lordship,
for me.
initially even I was of that impression, my
Yes,
Lord.
I was there under that impression.
Yes, Your
In
Lordship.
the meantime, this kind of a matter has not been, of course,
Yes, Your Lord.
taken up.
Yes, Your Lord.
So I was under the impression that cognizance, when we see the cognizance, cannot take cognizance, means I thought that the last is the cognizance.
Yes, Your Lordship. No, but
So now it's different,
that Sarah Matthew part clarify the cognizant part.
right?
But in Sarah Matthew case, Your Lordship, the Supreme Court was specifically deal with the complaint case, my Lord.
Mhm.
And in GR case, Your Lordship, none of this issue ever come up except for this Amritlal case and the Rajasthan High Court case, my Lord. Because in this FIR case, my Lord, the duty is cast upon the victim and the complainant to immediately report it, my Lord. And my Lord, the one more thing is there, my Lord. If it is considered as the date of limitation would be charge sheet, my Lord, it will giving more power to the investigation agency. If they don't want to
Yeah,
investigate
they
the
want to
matter, it will defeat the very purpose of the Your Lordship
Right.
court, my Lord. If they don't want to,
My interpretation, my case is also, if you don't know, I am also relying on this one,
Sarah Matthew.
Sarah Matthew,
Yes,
somewhere it is there in your favor.
yes, because
Okay.
object, Lordship.
Hmm.
Now for heinous offences, there's no limitation.
Mhm.
Article 21, right of the accused, which has been object of the Sarah Matthew, has to be interpreted in view of 468. Lordship. Because if you file one FIR today, for this four offences which maximum punishment is 3 years, you cannot keep the accused for 10 or 15 years to be tried. That has to be, that object has to be read at that basis.
Okay, this I'm keeping.
Yes.
So this staple, okay, staple. Yeah, we'll say hard in part. Yes, Your
Yes.
Lordship. Mr. Mr. Yu Bori, Ghana Council for Petition, next part, Mr. P. Ghana Edison PT. Topic, hard in part, lose this. Hard in part. Lose this matter after 3 hits.
Yes, sir.
Step. Okay. This is three petitions, similar.
Same, my lord, same.
Okay. Any other? Lodge.
Item number 20.
May I please, Your Lordship? Lordship, I am appearing for the petitioner here, but due to my ill health, I could not come down. I am praying if it can be fixed on next week, Lordship.
Next week.
Next week, Lordship.
You are for the petitioner.
I am for the petitioner, Lordship.
Okay.
Appellant.
County Council for the appellant. Let this matter be listed next week. Next week
Next week, Lordship.
or after a week?
After a week.
After a week.
After a week.
After a week. Yeah.
After a week. Okay.
Diploma.
Apply.
यहाँ दे दो, हाँ?